Please, Your Lordship. Okay, I beg to mention item number 24 of today's list. On last occasion, this honorable court was pleased to call for the case diary of the,
24.
yes, 24.
Case diary was called for earlier.
Yes, Lordship. Sheet has been submitted. Sheet submitted.
CS submitted. Yes, CS number.
Sheet number is 31/25. Dated 28/02/25.
You are in custody since when?
So I have to check from January, 23rd of January.
For a considerable period. So we'll just reflect your district.
Yes.
Otherwise, you have to move a regular bail application before the learned trial court below. So it will be disposed of. We'll pass a direction. Okay. Order to go.
May I please, Your Lordship? My lord, I would like to mention item number 3.
3.
This may be a password for the table. I have some technical.
At the request made by the Learned Counsel for the petition. Matter is adjourned, list accordingly. It will be listed after 2 weeks only. We cannot,
Immediately within 7 days.
no,
As your convenient.
2 weeks, after 2 weeks.
Well,
May I please, Your Lordship? I am praying for listing of an
Just when I have Yes,
May I please, Your Lordship? I am praying for listing of an anticipated bail application for motion, my lord. Actually, my lord, similar matter has been taken up by Your Lordship yesterday. Arising out of the
just
same
do
effect.
one thing, make a mention before court number 3. It may come before this court also, but mentioning before court number 3.
Publish.
Your Honor, item number 35 of Delhi lease. Your Honor, my senior is out of station, so may you please.
35.
35 Delhi lease. Your Honor, may please fix after below.
Your senior counsel name is,
AG Chaudhary.
you are on item number 35.
35.
His name is not reflected here. Huh? Oh, sorry, he is for respondent. I thought you are proposed.
Respondent.
MS so and so appearing on behalf of Mr. A.G. Chaudhary, the counsel for the respondent, paid for an adjournment stating that the Anchorage counsel is out of station. Prayer allowed list after 2 weeks. Okay,
May I please, Your Lordship? Lordship, the item number 4, Your Lordship. So in filing the appeal, there's some defect has been remained in the cause title. So I want to withdraw it with a leave to file a fresh.
actually, liberty. Or Mr. R.K. Bhuya, the learned counsel for the petition, and they submitted that there is some technical defect in the petition filed by earlier, and accordingly, he submitted that he may be allowed to withdraw the same with a liberty to file a fresh. Prayer allowed? Okay, you will be liberty to file fresh.
May I please, Your Lordship? Lordship, back to mention item number 27.
27.
Lordship, this matter, Lordship, similar matter of same affair, Lordship, pending before the court number 3, Lordship, maybe take it bail application number 475 of 2025.
That matter is fixed on when?
421. Lordship, I'm not aware of that date. Like this is not given it. Yesterday was matter fixed.
Yesterday matter was fixed.
Yes, Lordship.
So you want to tag it?
Yes.
Otherwise, we have received it here.
Actually, see. Oh, okay, then. Lordship.
So then you want to pursue this here?
Yes,
there
yes,
only?
Lordship, I.
Oh.
I'll like this.
My pleasure, Lordship. Lordship, here in this case, Lordship, the NBW issued against the petitioner, Lordship, and as on today, 62 days, Lordship, earlier rejected, Lordship. Only one thing, Lordship, and the petitioner was escaped from the dock, Lordship, and subsequently the learned court bill was issued NBW. And the first, Lordship, and he was appeared on 21/2025. And on that very day, Lordship, and as per the order reflected, he was escaped from the court, Lordship. And subsequently, he appeared after 4 days, 3 days.
Now, since when he is in custody?
62 days, Lordship, as on today, Lordship.
Actually, what had happened earlier, he moved an application.
Yes.
Did You have annexed the last order on page number 32. And the earlier the earlier order,
Lordship, and actually on that. day,
first
only
order was passed on
7-2 Lordship. Sorry, 7-1 Lordship.
7-1.
Lordship. That order,
You are
page
up
number
to
25,
appear.
page number 25. sorry.
Pardon?
He was asked to appear within 15 days
Appear.
to apply for the bail lordship. Then he was granted bail lordship. He was then appear, but he did not, at the last time, he was not there lordship. And his phone is
Yes,
also
yes,
switched off.
yes, yes.
lordship.
I have,
Lordship.
we filed an, the earlier application when he was filed this one on 24/2/2025 order was passed.
Lordship.
So I have made a detailed discussion there. So obviously 62 days can be done. Heard Mr. F. Hope, the learned counsel for the petition. And also heard Mr. K.K. Das, the learned additional PP appearing on behalf of state respondent. This is an application that is incorrigible. It is submitted by Mr. Hawk that the accused petitioner is behind the bar since last 62 days. And his earlier bail application was rejected on 24/2/2025. Passed in BA number 335 of 2025. Considering his length of detention already undergone, the prayer may be considered. And the petitioner is ready and willing to appear on each and every date before the learned trial court below to face the trial, if he is granted with the privilege of bail. Next prayer, Mr. Das, the learned additional PP submitted in this report that in the prior,
He recorded on the ground of his conduct lordship.
yes, on the previous occasion, when the earlier order was passed on, earlier when after this, after Agorata order, the 7-1 order you have annexed, 7-1,
Lordship, page number
which page?
25, Lordship.
please.
Page number 25, 25.
In previous occasion, no, in criminal petition number 6, 2025, the petitioner, criminal petition number 6/2015, sorry, 25, the petitioner was directed to appear before the learned court below within 15 days from the date of order. But it is seen that in spite of his presence, but in spite of the said order, he left the court premises without any intimation to his engaged counsel, and for which the NVW was issued, and he subsequently surrendered and he is in custody. So considering the conduct of the accused petitioner, Mr. Das raised objection in allowing him to go on bail. Next part, considering the submission made by learned counsel for both sides, and also considering the observation made in order dated 7/1/2025, passed in criminal petition number 6/2025, and BA number 335/2025, passed on 24/2/2025. I find that the further custodial detention of the present accused petition may not be required. However, he is required, and accordingly, I find it a fit case to enlarge the accused and so on and so forth. To the satisfaction of where?
Chief Judicial Magistrate, Gwalpara Lordship.
Case is pending where before?
And
CGM.
CGM Lordship, but on last occasion Lordship, on 18/3/2020, case is committed to the district and session judge Lordship.
Then district and session judge will be the court.
Lordship,
Is already been committed
committed Lordship, this is the order.
before the district and session judge with
Gwalpara Lordship.
Gwalpara, as case has already been committed from the learned trial court below.
Lordship.
With satisfaction for it. With a further direction, to the accused petitioner to appear before the learned session judge on each and every date of to be filled by the court. Okay.
49 of the supply list.
Four. Earlier, John. Oh, no. John. Oh, item 24. It's a connected letter. no? It's a connected letter with 24.
In 24.
In the morning, it is made a mention for some. No, not search is submitted. So in here also search is submitted most probably. It's a connected matter. I think. 49 is connected with 24.
Oh, Lordship. Same. PS case is same, Lordship.
So CS number is
Same,
same.
yeah.
None appears on call for the petitioner. However, it is submitted by Mr. Das, the learned additional PP. That case has already been charge sheeted by CS number same account 31/2025. In view of this dispose good. Okay, we are disposing it then. It means cease from you will have just a second. Darling, you don't mind when I repeat it. How would it? Dispose good. Disposing it.
With due respect, Lordship. Lordship, it is a case, Lordship. The teenage girl and boy is 25 years, Lordship. It's a love relation, Lordship. Item 50. Now, Lordship, the petitioner is in jail 206 days in judicial custody. Now, this affair, page 10. Page 10. May I read, Lordship? With due respect, I beg to submit that on so-and-so date at night around so-and-so time, we are residents of Sonapur PS in the village of the Patarkusi area when we are enjoying the Bihu function with my minor girl named so-and-so, age about 16 years. While my daughter went to shop for purchasing some goods during the Bihu function, Patarkusi, the accused person accosted her and abused her filthy language and pressed her neck and punched her with an intention to kill her. After that, she was grievously injured. Immediately, I went to the place of occurrence and rescued my daughter, but the accused person to flee away. Later, when I asked my daughter, she told me she and accused person had a love relation between them, but the accused captured some intimate photos in her without her consent and pretended to make said photos viral that caused the mental torture. This is the affair. And now, this affair, the register under section the Sonapur PS case number so-and-so and under section 323, 354, 341, 294, 506, read with section 8. And now, after that, Lordship, the IO had the file search sheet, Lordship. And after that, Lordship, the Honorable Trial Court, the framing of charge pays.
Charge sheet was filed under which section?
Lordship. Search sheet was filed, Lordship. Page 20, Lordship. Page 20, Lordship. The bottom line, five line. The below 5 lines, Lordship. Under section 341, 294, 354, 506, and 376 IPC, and read with section 8 of POCSO Act. And after that, Lordship, the Honorable.
76 IPC.
Yes, IPC.
Read with section.
Read with section 8 of POCSO, Madam. And now, Lordship, the Honorable Trial Court, the page Lordship 23, page 23, the framing of the charge 341 and 376 IPC, page 23, Lordship. 341, 376 IPC, as well as the 6 of the POCSO Act, on basis of the statement of the victims' girls 164 statement. And now, Lordship, the Honorable Trial Court, the informant and the victim girls, the court deposition already examined, Lordship. Now I am in jail 260 days, the local petitioner. And my lord, the delay lodging affair after 1 year, as per incident, kindly see this page 25, the deposition of the informant and victim guard. Victim lordship, page 28. The deposition of the victim, the court deposition, page 20. May I read, lordship? I am the victim. Informant is my father. I was born in so-and-so date. I know the accused. The accused I first meet at Holi in the year 2023. And her later messaged me on Facebook. After a few days, I saw the message and respond. He came to meet me, and next day I replied on 4/9/20, 4/9/2020. It's a crucial date, lordship. The 4/9/2023 in the year. I went till out 7 p.m. with my friend Preeti Boro and the accused friend. My friend was pillion rider on the accused friend bike while I was pillion riding on the accused bike later. Later, they took my friend home, but the accused took me to his village Patarkusi instead of dropping off me. Next page, next paragraph, lordship. He took me the Rudaxo Dhaba there where he had drink with his friend. I request the accused to drive me home because I felt uneasy with the accused friend starting at me and requested the accused to drive me home, but he did not. Next paragraph. The accused wanted to have sex with me. After his friend left, despite my resistance, he engaged in sexual intercourse with me. I asked the accused to drive me home again the following morning, but he refused. Next page. In the morning, the accused friend returned as well, and they got into a fight. The accused T-shirt was torn in the scuffle at around 1 p.m. The change his T-shirt went to his house and dropped me home. It took about 30 minutes to get from the dhaba to area around my house. Next paragraph, lordship. The accused then showed me his mother, sister, and other family members when he brought me to his home. After that, along with the calling me out, the accused also began the blackmailing me with the claiming pornographic picture which we would post on social media if he did not meet him. The accused had also shown me my naked photographs, his mobile phone. Additionally, he coerced me into giving the money by utilizing those pictures, and I gave him either 1,000 or 2,000 rupees, many times roughly 25,000 rupees in total. Next page. The
So
accused.
it's okay. Now these are the allegations. So still
Yes.
she brought some allegation. Yes, that's true.
Lordship, when it is there, Lordship, in your deposition, Lordship, in para 4.
Yes.
It's important, in para 6 is important, Lordship. Very clearly stated that he is, her consent is not there. Moreover, she is minor also, Lordship.
That is correct. After that, my lord, the page 30, the cross-examination part, my lord.
No, we are not going to
Yes,
read the
maybe not.
entire case,
Issue
entire
of
evidence.
notice has to also be issued, Lord.
Yes, notice.
Can you
has to-
see, my lord? The page 30, the paragraph
First
number
notice has
14.
to go. Before hearing you, notice has to go, no? Notice issue করে দিও।
And my lord, strongly they granted bail because undue delay explained in FIR.
No, we have to hear the notice has to go to the respondent.
Short
Or
that
take up.
date may be, my lord.
Respond number 2 through jurisdiction police station related to the office of the registry and the public prosecutor. So we can make it.
30. Please. Why is it in
Also call for the scan copy of the LCR along with the present status report. Registry will do the needful. And I guess notice has to go, so has minimum, yes, some time had to be there, so when it can be fixed.
8, my lord, 8 April, my lord. This 260 is a local person, my lord. Jurisdiction come of Metro, my lord.
Today is 26. Today is 26, Lordship. So 8, I don't think it will come, Lordship.
That's all.
Because it need to go to there and again it has to return back, Lordship. It took time.
It is sufficient, my lord.
Moreover, scan copies also need to be there.
Yes. This
Because
trial
it
may
is
be
search
come of
dated,
Metro, my
Lordship.
lord.
As it is search dated, so scan
I have
copy also,
Can we have already called for?
Lordship. I think lordship time.
8.
Then 11 lordship.
No, my lord, 11.
Then
And
eight-
8,
eight
9,
lords.
9,
8 or 9 lords.
9.
Nine.
Deeply obliged.
Item 2.
My lord, this writ petition is
Stay
filed.
also here. Yes. Here, MSSD is also appearing. I think name is there.
Lordship. Here, lordship, the state is not, state of Assam is not the party here.
Item number 2.
Item number 2, lordship. This is the writ
No, no,
petition
some
filed.
name of
they-
one
as they-
council is
as-
there reflected
as-
in MSD, SD,
Yes, they.
SD. He is representing the respondent.
Oh,
I don't know. Yeah, fine.
lordship, that may be by Mr. Because today is the first day, lordship, and no notice was served upon her. And moreover, lordship, because perhaps lordship, yes, there is representing State Bank of India, perhaps, lordship. But State Bank is of India is not here, party here. So
No, no,
notice is
he's
required to.
privately engaged, I think, because it's not, government is not here, party here, na?
Yes, lordship. But if he is engaged, lordship, then he is required to come before this court, lordship, at due time. Anyway, lordship, the fact is very simple, lordship. Lordship, I have taken a loan which was disbursed by the respondent number 1, lordship,
How
Reliance.
can you file here a read for watching or setting
Quasi-
aside of the case from in
Yes.
Kolkata?
Yes, lord. That regarding this, lordship,
Is it
there are-
entertainable? Can it be?
this is maintainable, lordship, because under 226(2), lordship.
Huh.
There are.
So why don't you move an application before the Kolkata High Court?
Because, lordship, I am the resident of here.
No, whatever.
Yes,
Case is
lordship.
there, you
and-
want to
and-
pause the case from there.
And most of the cause of action is. within
We are
the
not
jurisdiction
to,
of
we
this-
are not to see the very cause of action and all. We did a read, we filed a read. And the read, you are paying something.
Yes,
So
lordship.
there is a judicial issue, if you raise the judicial issue, that has to be there in Kolkata only.
Similar circumstances, there are so many judgments by this
Whatever.
honorable court.
Okay,
Your
we are
lordship may
issuing
kindly
notice
peruse,
here.
lordship. Lordship, in the meantime, because, lordship, I have, as per, they have filed 2 cases, lordship. Earlier
Whatever, we
case-
are simply, without hearing the other side, we cannot pass any such
Lordship,
kind
at
of
this
order. We are
stage, lordship,
seeing only
kindly,
issue notice.
lordship, till, lordship, them represent, lordship, the,
State
uh,
of West Bengal represented by Principal Secretary,
yes, lordship.
investment infrastructure, small business by so and so. কোনো কৰিব, hard কৰি দিওঁ। Issue notice কৰিব, simple. Issue notice to the all respondents.
Lordship, case is required to be stayed, lordship, because lordship, on same cause of action, lordship, earlier on settlement, lordship, they withdrawn, lordship. Subsequently, they filed
Let
again
us,
on
let
same
let
cause of
the
action.
other side appear in Mrs. MS Day is here, so I don't know she is whether, how she is, name is there in the reflected. এটা খালি লিখি দিব,
Otherwise, your lordship, may
in the
fix it.
cause list, the name of MSSD is reflected, however, she is not present today, issue notice কৰি দিব খালি, no? List accordingly after 4 weeks. No, we are not going past any stay order. List after 4 weeks,
Lordship, a date may kindly be fixed, because lordship.
after 4 weeks,
After 4 weeks, a date kindly. Otherwise, it will not be.
5.
Obliged.
Item 5.
Right, please.
Yes.
Lordship, this is a criminal petition, Lordship, under section 520, Lordship.
Hmm.
So, Lordship, an FIR has been lodged, Lordship, under section 303/2, Lordship, BNS. And Lordship, after lodging the FIR, a person has been arrested, Lordship, and the stolen materials has been recovered by the police along with the vehicle, Lordship. And subsequently, Lordship, on the basis of that arrested person, Lordship, on the basis of his statement, the police came to know about an excavator also used in the said offense, Lordship. And I am the operator of that excavator, Lordship. While police detained that excavator, Lordship, at that time I was operating that excavator. For that reason, only I-
Excavator is also seized by police?
seized by police, and subsequently it is under the custody of the owner by the Zimma order. Lordship. But excavator was seized in from another location, Lordship. There is only the allegation, Lordship, by the co-accused, Lordship. Now, Lordship, For that reason only, as because I am the operator of that excavator, I have been implicated in this matter, Lordship. And I have been arrested and subsequently I got bail, Lordship. Now, Lordship, for that reason, Lordship, I have been preferred this petition, Lordship, so that
The case is
Yes.
still under investigation stage or it is already been charged?
not charged, Lordship.
Not yet charged.
Not charged. Lordship, for that reason, I have, I want to give some citation also, Lordship, in this regard. Lordship. Point number 8, Lordship, it is the High Court of Madhya Pradesh. Lordship.
Hmm.
Even highlighted. Lordship.
Hmm.
May I read, Lordship? Therefore, in view of the appropriate discussion and the observation made by the coordinate bench of this court in the above case, as the information given or disclosure made by the co-accused person to the police does not lead to recovery of any identifiable material from the possession of the applicant, the prosecution of the applicant is nothing but abuse of process of law. Hence, the petition is allowed. The FIR and charge sheet bearing number so and so registered a police station Tata district Ujjain against the applicant and subsequent criminal proceeding pending against are hereby quashed. Applicant is discharged from the charge levied against him. His bail bond, if any furnished, stand discharged also. So I'm
Yes.
relying.
To say the passing of the FIR, so CD is necessary, Lordship. CD need to be called, Lordship, to see whether prima facie material is there or not.
So, Lordship, here I have annexed the forwarding report also. Lordship, in forwarding report, it is also clear that page number 18, Lordship.
18.
Page number 18, Lordship.
Hmm.
Here the recovered material and the person who has been arrested, his name also here reflected here, but my name is not here, Lordship. And Lordship,
This is forwarding report of whom?
forwarding report of the.
Yourself.
No, not my forwarding report, this one. But
This is whose
the
forwarding
person, the
report?
person who is the co-accused, Lordship.
Co-accused forwarding report. And
Co-accused.
you have annexed your forwarding report?
My forwarding report,
You have not annexed.
Not attached,
Then
Lordship.
how can we know? Yes, that is the reason finding some materials against your co-accused. He was forwarded. During the investigation only your name has come because while lifting the stolen vehicle, your excavator was used. That is the case. So you were there and at that time while lifting the car or it is stolen, at the time you were the person who was operating that.
Not-
Then what else you need? What else you need? You were the person who was operating the excavator while the car was lifted. Obviously, it is a stolen. Obviously, car was stolen. Otherwise, why it will be lifted for some other place? After that lifting of the car, your excavator may be parked somewhere. What is this? It's not a case of directly to pass any order on stay of investigation. Definitely, we are not going to stay the investigation. Let the city be called. There may not be any material also. That is understood. You may be falsely implicated also. You simply maybe a direction may be given to you for lifting the car. That may be there. I won't disagree with you, but
My concern
for
is-
them, we have to see.
I'm just an operator. At the time of detaining the excavator, I was operating the vehicle, but not in the.
Why
case
don't
of-
you enquire anything while operating, while lifting the vehicle from a place? You could have why is it the car is in condition, mechanical, any mechanical defect is there, anything is there, you should
Hmm.
enquire everything.
Okay, city may be called.
Anyway, you may be engaged for lifting the car, you may not be aware of, I can understand this one. So CD call for it, hard Mr. So for it, ma'am, liquid now. This is an application for before and CD call for it. When it can be fixed,
11, Lordship.
when we are not going to fix some matter. Huh?
Then need to after Bihu then.
Obviously, it will be after Bihu,
After Bihu,
because
but
he is in,
there-
you are in bail,
Yeah, like,
okay, after Bihu.
Lordship, 124.
24.
Lordship.
Let the material of the CD be paid, then we'll pass the order. On the day the CD comes, we'll try to dispose of the matter. Hello.
Item 6.
Yes.
Lordship, I've come to the
Hmm.
portion of the FIR, which is at page 18. Lordship, an FIR was filed. What had happened is that we entered my,
Page number 18 FIRs.
yes. What happened, Lordship, I may just say immediately that we entered into a deal with the respondent to sell a property. And as an advance, I was paid 50,000 rupees on 50 lakhs, Lordship, on 23/4/2025. Thereafter, I went on asking them to give me the full advance, which was 1.5 crores. And they did not pay that. We are willing to share the property. Only thing is that I have another suit. They said that I concealed the fact that I have another litigation pending. But that litigation was being resolved and the respondent was very well aware of that fact. In fact, they went and spoke to them also. But nevertheless, when I insisted on the money, they couldn't pay the money, they filed. And I said, if you can't pay the money, we're going to forfeit it. And they filed this FIR. And on the same ground, they also filed a civil suit where they asked, their prayer was to sell the land, specific performance to sell the property, which we are willing to do anytime. And now, Lordship, what has happened? Immediately after filing the FIR, within a week, my bank account has been seized. And Lordship will find that is at Annexure 2, page 22. With reference to the subject cited above, I have the honor to report that on 2/3/2025, a complainant named Matiur Rahman lodged an FIR stating that one person, namely Roman Borthakur and Vishwajit Borthakur, took 50 lakhs from the complainant to sell land of 2 kathas odd at Torunnagar, ABC near Raj Bhavan, but they neither handed over the land nor returned the said advance money to the complainant. During preliminary inquiry by Bhangaghar PSK number this, it is found that the transaction of money is true and the complainant paid the advance amount of rupees 50 lakhs by demand draft. Now, this is the reason why they seized my bank account. 31st is coming. I have to pay my dues. And moreover, Lordship looks at the FIR. What does it say? It is basically just a civil dispute, which is at page 20. With the subject noted above, I beg to being the informant, beg to inform you that the accused person is the owner of a plot of land measuring this and this at number this, and the locality is known as Bylane number 2, Torunnagar ABC near Rajiv Bhavan, GS Road, District Kamrup Metropolitan, Assam. And the accused person's company has been running a hotel business in the name of Agnideep Continental in the building constructed over the said land. Due to financial problem faced by the accused persons and further convincing us that the same land and property is free from litigation, mortgage, etc., the accused persons promised my family members, including me, headed by my mother, namely this, to sell the said land and property to us, and accordingly, and 23/4/2024, the accused person number 1 acknowledged the receipt of amount of 50 lakhs as token money, drawn on Punjab National Bank in the name of RB Brothers Plantation Private Limited by issuing a receipt on 23/4/2024. The accused person number 2 is well versed about the same, but subsequently we came to know that some suit is pending between the accused persons and Repose Company regarding the said land and the building standing thereon belonging to the accused person, and such information has destroyed all our hopes and expectations. The accused person number 1 received the money amounting to 50 lakhs from us on 23/4/2024 through demand draft number this, drawn on this by playing fraud. Hence, on 22/6/2024, we requested the accused person to return the said amount of 50 lakhs only along with the compensation to us. The accused persons did not return the said money to us. We again requested the accused person to return the same amount along with the compensation. Then the accused person number 2 threatened us with dire consequences and asked us dire consequences. So this is what has been said, and on the same ground, a suit has been filed. Basically, it's a civil dispute, Lordship. And I am at present, I am aggrieved by freezing of my bank account, 31st of May, just because the money was deposited into my account. Cannot be a ground for freezing the account. I am a commercial, I do business, Lordship. So Lordship, notice may be issued and only pray the bank account may be unfreezed.
Please, I have to see the record. In fact, in that regarding the freezing of your bank account, have you filed any application before the court below?
No, Lordship, I
Why?
did not, because it's not before any court. Only the FIR has been filed,
FIR
has been ready, only the
So
FIR.
now you want to quash the entire FIR or want to quash the which border?
I want to quash the FIR.
Ah.
I've come here
Yes.
before your Lordship. Now I have to file it, unfreezing only for the police now. The matter has not reached the court.
No, the matter has not reached the court. For unfreezing, definitely any application, any petition, you have to move before the court. Either here you have come for a quashing. That's why I'm
Yes.
asking.
As
Is
a
it for a quashing or only for defreezing?
No, quashing.
For quashing.
For quashing.
Okay then.
So
Yes.
Here I wanted to state here, Lordship, in the FIR, if we go through it meticulously, Lordship, then it is stated that the main allegation is that, Lordship, that some suit is pending before the person's, Lordship, between the accused person and the repose company regarding the said land. There is a suit already, Lordship, but they have not disclosed it to the complainant, Lordship. And on that account of that, Lordship, they have taken money. And section 420 is there, sitting, Lordship. So, Lordship, then some materials has to be there, Lordship, from the prima facie, Lordship. Moreover, that it is freezed because 50 lakhs has been taken. And it is related to the investigation, Lordship. That is why it is freezing, has been freezed. Without going through the report of the IO, Lordship.
You have
It
to
is
call for
needed
the
on Lordship.
report as well as you call for the case diary
Lordship.
also.
And it's
Yeah, along
only
with the case diary, we are calling for the report from the IO
Lordship.
as to further freezing of the
Lordship.
bank account is whether necessary under what we will see to it. He will definitely will file a report unless we have to, because but the question is that the 50 lakhs may be deposited in that account, but he is operating that account
For
to
my
other
business
countries,
purpose.
other transitions also.
my
mostly.
business for other conditions also. And the 50 as on 50 you have the bank statement.
But the account is related to the offense, Lordship. That is.
Yes, obviously,
The
obviously.
offense will, the account will not run away, my Lordship. It will be there, but at least let them unfreeze.
Lordship, report has
So,
to be there.
and how do I pay my excise dues? How do I pay my dues, which I have to pay by the 31st of March? This was frozen on sometime in 11/3. How do I, Lordship, after that I've been going to them, they've not done anything before coming to court. So now how do I pay this dues?
And anyway, we have to call for the report, otherwise we don't have MT 20.
Lordship, for the time being, till next date, at least it may be unfreezed.
No, it cannot.
Because what will happen if it's unfrozen, Lordship? What prejudice will be caused? No prejudice.
It will the IO, Lordship, that will take.
Because
Invest-
if I have committed a fraud, it is my action. I'll go to jail, I'll have to pay a fine, whatever. My bank account has no role to play in that. Just because you deposited there, does not make that a part of the account statement. If they want to verify, they can still verify.
So why don't you, I mean, during the investigation, you could have taken a steps, or you could have made the person concerned that we are going to return the money, we are ready to return the money.
Ready to sell. We said that we are ready to sell.
But your other litigation is still pending,
No, the other litigation is being sorted
still
out.
pending for the same land.
No,
that is
that is being sorted out, Lordship. That is
So
being
show all this place, all this before you are on bail, I think.
no.
You are not on bail also. Then
I'm not on.
if you could have applied for bail and you could have I mean, furnish all the related documents and then you are also ready to, these things were to have been produced before the IO concern, so that he can also investigate the matter, and then if you are ready, then
There's no
obviously.
warrant or no warrant, nothing. We just came to know only, actually, we came to know about the existence of this only when
But
our
against
bank,
you, one FIR has been filed.
no, only when my account was frozen. I didn't know
Whatever you have
before
not,
that.
why don't you approach the court below for seeking bail also, you can put up.
No, because there's nothing, no warrant, nothing. Only now I have come to know.
Okay.
I don't apprehend that I'll be arrested. That
Heard Ms. M. Hajarika, the learned counsel for the petition, and also heard Mr. K. K. Das, the learned additional PP, appearing on behalf of state respondent. Luckily, this is an application, section so and so, in connection with so and so. Issue notice to the respondent number 2. No formal notice is required to be served on the state respondent number 1. CDB called for. However, it is submitted by MF Hajarika that the bank account has already been freezed, which was related to other transactions, and hence she prayed for defreezing the account till next date of listing. In that context, Mr. Das, the learned additional PP, submitted that the bank account has been freezed in connection with this case, and without any report from the IO, he raised objection in defreezing the said account. Accordingly, let detailed report be called for from the IO as to whether freezing of the said account is further required in connection with this case, along with the case diary. Mr. Corning, when it can be listed?
tomorrow, Lordship, 31st.
Tomorrow will not come.
Lordship, then
Tomorrow it will not come.
day after.
Friday.
Because Friday, because otherwise 31st is a Monday, it's a holiday. 30th is a Sunday.
Okay, Friday will be listed. Try to, but the other side will not be there, no?
Other side need to also be need to.
Why
Okay.
the other sides, they want the report from the IO, IO is investigating.
Otherwise, there is no.
What
issue
are
of
you,
also
that means
giving
the
notice.
police
No,
is
I
acting.
will.
Lord Lordship, that is obvious, they are
I
acting.
will definitely try, but it is there, name is there, Lordship. Otherwise, there will be no issue of naming him Lordship.
Lordship,
Otherwise, there will be no need of giving him notice, Lordship. I am on that only.
no,
I can handle the case, Lordship. I will try.
because that
Okay,
is
we're fixing
something
it on 20th, let us see.
Lordship.
that is IO has to do,
Okay,
or are
I-
you work,
I-
are you
I-
hand in gloves with the accused?
No, no, I will.
I mean, it
definitely.
seems like that.
28th.
7.
May I please, your Lordship? Lordship, I have filed this criminal petition under 528 to quash a criminal proceeding against me along with FIR charge sheet and subsequent order, Lordship. Lordship, may kindly see
Subsequent order means case is charged sheeted.
charge sheeted, Lordship.
What is the stage of the case at present?
Someone has been issued, Lordship.
Summon issue.
FIR page 14, Lordship. May I read? মহাশয় সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 2023 চনৰ পৰা 1 নং পদকীয়াৰ লগত ভালপোৱা আছিল আৰু মোক বিয়া কৰিম বুলি মোৰ লগত শাৰীৰিক সম্পৰ্ক কৰে যোৱা ইংৰাজী 18/11/2024 তাৰিখে মোক বিয়া কৰিম বুলি 1 নং পদকীয়া ঘৰত মাতে আৰু মই যাওঁ কিন্তু মই 1 নং পদকীয়াৰ ঘৰত যোৱাৰ পিছত মোক বিয়া নকৰে বুলি কয় আৰু 2, 3, 4 আৰু 5 নং পদকীয়াই মোক ঘৰতে মাৰপিট কৰে আৰু ঘৰৰ পৰা ওলাই দিয়ে Lordship, here there were 5 accused and after the FIR I got bail on 6/12/2024 and charge sheet has been filed on 10/12/2024. Lordship, may kindly see charge sheet page 25. Point number 16, brief facts of the case. The brief of the case is that complainant Sakina Khatun so-and-so lost a complaint to the effect that she left accused number 1 Samiul Islam from the past 1 year and Samiul Islam had promised to marry her and made physical relationship with her. And on 18/11/24, Samiul Islam called her to his house, and accordingly, the complainant went to the house of Samiul Islam. After reaching his house, Samiul Islam told her that he would not marry her, and other accused persons have beaten her and asked her to leave their house, hence the case. During the course of investigation, all possible actions have taken away with the case, and case is found to be well established. Accused person, namely Samiul Islam. Charge sheet has been filed against only one person, that is me, Lordship.
Under which section?
Section 69 and 3082. Lordship, in the third paragraph, during the course of investigation, the victim was sent for medical examination at Chapor CHC. As she has reported that she was beaten, the medical report was collected where the doctor opined no injury, Lordship. During the course of investigation, the victim was also sent for medical examination at DMCH. As she was reported, the accused Samiul Islam had made physical relation with her, but the victim refused medical examination, Lordship. And during the course of investigation, the victim was sent to Honorable Court to record her statement under Section 183 BNSS. And in 183 BNS statement, the victim stated that she loved Samiul Islam from past 2 years, and he told her that he will marry her and did physical relation with her on 20/11/2024. And previously, Lordship, on 18/11/2024, if the incident occurred soon after 1 day, how can it possible on 20/11/2024 I made physical relation with her at my house, Lordship? So no case is made out on the basis of complaint of charge sheet, Lordship. My humble prayer is to stay the proceeding and notice may be sent.
Your Lordship, 69 is there. As per section 9, ingredients are there, Lordship. Prima facie, it has been there, Lordship. The materials are there. So, Lordship, if the prima facie materials are there, quashing cannot be done, Lordship. Otherwise, Lordship may call the scan copy, Lordship.
Otherwise, you are on bail, I think. You are on bail.
I am on bail, Lordship.
Next date is fixed on bail.
13 May, I think.
13th of May.
13 May, it is first day, Lordship.
No,
Someone just issued, Lordship.
Actually, someone just issued.
Yes, Lordship. Lordship may
Is
kindly.
there any compromise between you regarding this period in this
No,
period?
Lordship.
Hard for it. And so for it, issue notice to the respondent number 2. To register ready, no formal notice is required to be served on the state respondent number 1. However, requisite copy may be served during the course of the day. Also call for the scan copy of the LCA along with the present status. Yeah, scan copy also one item. Along with the case diary. Along with the case diary.
Lordship may kindly stay the proceeding.
Stay the proceeding is not possible because as he submitted that if you go by the prima facie materials in the FIR, it reveals a case against you under section 69. I don't know about the injuries, but 69 is there.
May kindly see page 18, last submission, Lordship. In the bail order, Lordship, Honorable High Court mentioned that it is a settled position of law that simple promising to marry without anything more does not constitute any offense.
Lordship, 69 may, if he is insisting, then I can
69
read
itself
69,
is
Lordship.
under challenge, Lordship.
69 is under challenge of case, but 69 is still there.
Yeah.
So that is the case. Otherwise, it may not be a case 376 directly, I would say.
Not among
But the question is that under the false pretext of
Okay.
marriage or promise of marriage,
Lordship,
some physical relationship was there. That is the case only.
Lordship.
So if you are going to pass, obviously your 13 May is there. We try to get it before 13 May. Okay.
Lordship.
Yes, get that. You know, you take steps for issuing notice also. You had made a respondent number 2 there. So take steps for issuing notice to the respondent number 2.
Lordship.
7th of May. We are listing it on 7th of May. We'll try to dispose of the matter on 7th of May itself. Stay in here.
Item 8.
Nine.
My pleasure, Lordship. In this case, like, there are 6 accused persons, Lordship. Four accused persons have already been granted by the trial court, Lordship. This is the order.
You are the main accused.
Lordship. In fact, Lordship, main accused is here, Lordship. It's Mujibur Rahman, Lordship. No, Lordship, Ramzan Ali. Ramzan Ali is the main accused, Lordship. In fact, Lordship, Mujibur Rahman, Lordship, petition number 2, he was not present at the date of occurrence, Lordship. He was in Arunachal Pradesh, Lordship. But subsequently, this FIR has been lodged, Lordship. And
What
in fact,
nature of offense? First tell
Lordship,
us.
Lordship,
What kind of offense is this? Section 8 is
8
there.
of POCSO Act is there, Lordship. But Lordship, in this case, there is a cross FIR also. FIR page 8, Lordship.
Now see, whatever may be the position, the now position, the now present situation is that we have to issue notice. We don't have any alternative because there is strict, that the order, I mean, observation. So any stage, anything, you have to hear the respondent side. So issue notice, there may be a case for bail, I won't disagree with you.
The short date may fix, Lordship.
We don't have any short date. Short date means when we want.
From Nagaon, Lordship.
No, Naga, we don't have. Naga will come. It will be obviously immediately
Because,
after Bihu, we don't have any
Yeah,
other.
as
short date.
there is no interim protection, it 8 of POCSO is there.
What
Anytime he may be taken into custody. That
what
is
to
there.
do? We
That
don't
is
have
why I'm
any.
insisting.
কিয় পাৰিব নেকি? মাথা খাৰাপ হৈ যাব এতিয়া। Well, I'm insisting on after Bihu. 21st. Immediately after Bihu on 21st.
21st. Apply.
So you take stage today itself
Yes.
to Judicial Police Station, routed to the Office of the Registry and the Public Prosecutor.
The nine.
Well, please, your lordship. Your lordship earlier rejected this bail application in your my lord. That though I made a detailed disclosure in my petition, but inadvertently, my lord, that order has not been placed, my lord. The rejection order, that you also you'll remember that alternative medicine, the doctor raised that alternative medicine. My lord, that the allegation is that Madam Abdullah Ahmed made a complaint
So
to
what new ground, with what new ground you have?
that I have already discovered. You also hereafter, my lord, you also rejected the said bail application, saying that the privilege of privilege bail cannot be done at this stage. Thereafter, detailed investigation has been carried out. The you also kindly called for the my lord, the up-to-date case diary, my lord. Thereafter, I my lord. That I know, my lord, I placed all the documents before the IO, my lord. They carried out investigation thoroughly, my lord. You also kindly called for.
Oh, you appear before the eye also,
No, my brother submitted entire my lord documents before the IO, my lord.
all documents.
All documents, my lord. And also, they also came to my clinic, my lord, carried out the investigation thoroughly, my lord.
Very nice. For the case diary, when it can be fixed? No, prior Bihu, we don't have it in dates. Prior Bihu, we don't have any dates.
On 24th.
24. We're calling for the case diary on 24.
In the meantime, my lord, if possible, my lord, in the meantime, my lord.
You won't get arrested. We all are there. Your police chief visited to you. You have your brother visited to police. Police visited to you. I don't think you will be arrested.
No, no, 24, my lord.
Yes.
51.
50. 51.
Wait, please, Your Lordship, can you pass over the matter for the time being, Your Lordship? My senior is in court number 1 on next.
Mr. Chaudhary is there.
Can you pass over the matter?
Yes. Okay then. Okay.
For Indian, item 18.
Yes, Mr. Chaudhary.
Lordship, it can be at 2 o'clock, Lordship. I've got some of the matters are finished.
At 2. Okay.
It will be convenient for.
Yes, yes, okay. Number? 80. Very. Yes, 18. Mr. Bora is appearing on 18. 18, no one is here. The scan copy you have received already?
Yes, my lord, still copy.
None appears on call for the petitioner. However, it is submitted by Mr. Rajay Borwa that the scan copy of the case record has already been received. List accordingly after 2 weeks put it, list after 2 weeks. It's a NDPS?
NDPS.
Acha.
19.
Lordship, can you take up the additional affidavit, my lord?
Additional affidavit.
Affidavit, my lord. Case 66.
Page 66.
66.
Yes,
No ground of arrest, my lord.
yes, prosecution, what your
My
prosecution
lord,
is
I
doing.
have already submitted, my lord, the ground of arrest is not a new thing, my lord. It is specifically mentioned.
No, no, it's okay, but what
my lord,
steps they are,
Earlier, my lord, it was followed that, my lord, only the case number has been mentioned, my lord. And it is mentioned that you have been arrested in connection with this so case, my lord. And that is why you have been forwarded to the trial court for, my lord, court, my lord, for the purpose of further investigation, my lord. Now, my lord, after, my lord, the Vihan Kumar and, my lord, Praveen Puker's judgment, my lord, Supreme Court has clarified, my lord, that for what offense, my lord? Exactly the for what offense, my lord, if it is narcotic drugs, then, my lord, the what contraband has been recovered from and seized from his possession. That has
full
been mentioned.
particulars has to be there.
Yes, it's my particular, my lord, that is has to
No,
be
I'm
specific, my lord.
just, I'm asking you what the director prosecution or the prosecution is doing now.
My
presently.
lord, after this, my lord, Praveen Pulkar and Gihan Kumar, my lord. Now, my lord,
No,
we have been
now,
informed that, my lord,
from yesterday,
now, my lord, grounds of arrest
it's
has to
been
be
followed, my lord.
Been
And not
followed.
only, my lord, by the, yesterday they have served, my lord, in one case, my lord, in English also, in vernacular also. my lord. Now, there is no respite for us, my lord, regarding the Vihan Kumar.
It is not a new thing, my lord, but Supreme Court has clarified, my lord, that has to be specific, my lord. This is the law.
Yeah, this is the law, that's what we are on.
Now, these are, my lord,
Anyway, so you are pointing out that there was no grounds of arrest on 47 BNS.
Yes.
And apart from that, is there any other? Now your petitioner
Only
is in,
investigation is over already. He is in custody.
4 months after
4 months after the, my lord,
truck was apprehended.
truck was apprehended. Thereafter, we have arrested after the 4 months. When the truck was already apprehended.
no, you got arrested after 4 months.
After 4 months of the apprehension of the truck, my lord.
that is a lawsuit rejection order, my lord. Lordship may kindly peruse, my lord. Rejection order of the lordship is page 51, my lord.
At that time, we are not privy to this document.
Yes. This is the earlier rejection order.
Rejection order, my lord. Because, my lord, lordship is, my lord, deals with all the details, my lord, including the case laws, my lord. And there were sufficient material, so lordship is, my lord, earlier rejected this bail application.
That was prior to charge, my lord. Now charge has been framed. No witness examined. My lord. We are in custody for more than
6 months.
6 months, my lord. 6 months, 10 days, my lord.
Charge frame now.
Charge been now framed. So. My lord, please separate.
SARS frame on, my lord, 4/1/2025, my lord, recently, my lord.
Now
My
I'm
lord.
relying on the lordship judgment of the Sofiul Ali, my lord. That's well done.
So they basically, Mr. Bora is relying on, stretching on the point of the non-furnishing of, non-mentioning of the grounds of
My
arrest.
lord, only that ground, my lord, that part I leave it to your lordship, my lord, with my objection, my lord. But other, my lord, as far as, my lord, the recovery and my lord, other
Is there.
parts are concerned, my lord, there are
We are
sufficient
not, at
evidence,
this
my
stage,
lord.
we are not, my lord, on that, my lord.
There are
There's
sufficient.
already been rejection on that part, my lord. Only detention and the, my lord, Vihan Kumar.
And my lord, as far as my incarceration is concerned, my lord, that is also not there, my lord, because my lord, on 4/1/2025 search frame, my lord, and now the case has been posted on 13/3/2025, my lord, for production and my lord, evidence, my lord.
In 3 months.
My lord, my objection may be recorded, my lord, regarding 47, my lord.
47, he cannot give any objection, my lord. That is the mandate of the Supreme Court. How he can give
Supreme
an
Court-
objection in the Supreme Court
has
verdict that
clarified,
the, my objection in a law point, how is it settled point that how can there be an objection by the PP? Maybe on the different points, we cannot object on the
My
legal points.
objection, my lord, on as a whole, my lord.
That is a different issue. On the Vihan Kumar 47, they cannot object neither anybody right now.
Okay, sir.
Dispose of, my lord.
Yes, it will be disposed. of. Pass your.
All right.
Deeply obliged, my lord.
Format the same thing. So the Papa or the. To 18, 19, I think. Disposed.
20,
We also, we have received this scan copy, Mr.
Yeah.
Purva.
Scan copy receipts.
Yes.
May I please, Lord? My lord, here is also a case, my lord, of NDPS Act. Now, your lordship will find from the materials on record that the only offense is that he happens to be, my lord, the father of the accused, my lord, who was earlier arrested in connection with, my lord, the present case. Now, certain, my lord, contrabands were recovered from the son of the, my lord, the present petitioner. Now, the son, my lord, is presently behind the bars. My lord, nobody has moved, my lord, any bail application on his behalf. Now, the present petitioner, my lord, having been arrested on 19/9/24, presently, my lord, he is behind the bars for more than 6 months. From the FIR itself, which I'll come, my lord, I'll draw your lordship's attention that it appears that he's not a name accused, present petitioner.
Not everybody.
No, my lord, recovery has been made from his possession either. And secondly, my lord, the twin requirement of 37, not, my lord, being present to detain him under custody, he is entitled to be released on bail. From the forwarding report, it appears, my lord, that the police has arrested the present petitioner on the ground that the son had named, my lord, his father, saying that he had, my lord, induced him to, or to, my lord, carry on the present, my lord, the transaction, my lord, regarding the contraband. So this is the only material. Now, in terms of, my lord, Tufan Singh, my lord, the statement under 67 is not admissible. The third ground, my lord, which your lordship has also considered in the earlier application, I have, my lord, flag marked it, neither the arrest memo nor the, my lord, notice under 47, the grounds of arrest, my lord, is available. So in terms of Probir Purokasto and the subsequent judgments, my lord, Vihan Kumar, I am
Where is
entitled,
flag mark? Where is flag mark?
I have flag marked in the, my lord, scan copy.
Oh, your name is?
My name is, my lord, Safaruddin Ahmed. This is the arrest memo and, my lord, notice under section 47. Now, what the Supreme Court says, my lord, only 2 lines on the failure to comply with the requirement of informing grounds of arrest as soon as maybe after the arrest is vitiated. Once the arrest is held to be vitiated, the person arrested cannot remain in custody even for a second. So this is the law now, my lord, which has, my lord, settled the proposition of regarding, my lord, the notice. And secondly, arrested on 19/9/24, he was produced on 29/24 the next day. And therefore, my lord, the grounds of arrest not having been furnished, the very remand by the magistrate becomes illegal. In absence of the ground of arrest, my lord, the remand, my lord, stands vitiated, my lord. And in my respectful submission on this count alone, in the light of the Supreme Court judgment, my lord, he cannot be detained for a single, my lord, moment behind the bars. And therefore, my prayer is, my lord, on these grounds, your lordship may be pleased, my lord, to release him on bail. More than 6 months, my lord, behind the bar. No possession, nothing. No recovery from his possession and nothing. Only a statement from the co-accused, my lord. And his only offense is that he happened to be the father of the, my lord, that accused man, and nothing else. So it's an open and shut case, my respectful submission.
Well, it's a search that case, my lord. So during, after investigation, my lord, police has submitted search sheet, my lord, and showing, my lord, 3 person is in absconder, my lord. But I'm sorry, my lord, 2 person absconder, my lord. Now, my lord, on 9/1/2025, cognizance taken, my lord, and someone issued to the, my lord, the absconder accused person, my lord.
9/1/2025.
9/1/2025, my lord, cognizance taken, my lord. And regarding, my lord, these are the organized crime, my lord. Because during investigation, my lord, police will have to rely on the, my lord, the co-accused statement, my lord, to proceed further in the investigation. And regarding, my lord, the 47 notice, my lord, I have already submitted, my lord, in the other cases, my lord. In this case also, I have seen, my lord. The 47 notice has been issued, but, my lord, the ground of arrest, my lord, as, my lord, mandate in the, my lord, Vihan Kumar and, my lord, Provin Puttas case, my lord, that has not been, my lord, specifically mentioned, my lord.
Totally upset. If I say so, totally upset.
Now, earlier to, my lord, these 2 judgment, nobody challenged, my lord. Because everybody has accepted, my lord, whatever the ground of arrest was furnished, my lord, that was accepted, my lord. Now, my lord, when the Supreme Court has clarified, my lord, that there has to be specifically mentioned the ground of arrest, my lord, then, my lord, this issue has arrived.
So for your lordship's convenience, FIR at page 19, my lord, and the forwarding report, page 30. So on these grounds, my lord, I may not elaborate further. On these grounds, my lord, your lordship may be pleased to consider my bail application. There are 2 forwarding. My forwarding is at page 30, my lord.
Please, 1-3.
30, my lord. And para 4 and 6 makes it clear that, my lord, I am the father of the accused, my lord, the arrested accused, Sihat Ishtak, and I am the owner of the vehicle. These are the grounds, my lord, and nothing else. Deeply obliged.
Twenty-one and 22.
So I am appearing in item number 21.
21.
21. Petitioner is Raju Banerjee. Mr. Lord, application method under section 483, I was arrested on 30/8/2024. As on date is about 208 days. The charge sheet has been submitted on 31/10/2024. till date, my lord, none of the prosecution witnesses have been examined. Now, so far as the allegation is concerned, my lord, the FIR is at page 16. I am not named, nor any recovery has been made from me. My lord, from this FIR, your lordship will find that 2 persons have been named and they have been arrested along with their vehicle. And during their interrogation, they have revealed name of some other person, not the petitioner. And my lord, the copies of 161 statement, those were supplied to me. What I find, not a single witness examined by the my lord, police has revealed my name. Not a single person. But the police, my lord, the GD entry they have relied on. The case record scan copy has come perhaps same. And the GD entry, my lord, dated 38/2024. But it isn't mentioned. It is to be noted that during investigation of the case, information received that the suspected accused Raju Banerjee was loitering at Sarupathar town. Accordingly, I, along with PS staff, arrived at Sarupathar town and apprehended the suspected accused Raju Banerjee with the help of Sarupathar police. But to be suspected, not a single person has uttered his name. And there is no link that has been come to their notice to suspect the present petitioner. Now thereafter, the GD entry, my statement is recorded. And there I have implicated myself. That is the only statement and the entire the case record that was available with the court, and they are trying to rely on. So relying on this Tufan Singh and subsequent judgments, this Palulabit Ahmad Arimutta, that is of 2022 Supreme Court. Relying in paragraph 9. Paragraph 9. Having gone through the records along with the tabulated statement of the respondent submitted on behalf of the petitioner NCB, and on carefully perusing the impugned orders passed in each case, it emerges that except for the voluntary statement of accused number 1 and accused number 2 in the first case, and that of the respondent themselves recorded under section 67 of the NDPS Act, it appears prima facie that no substantial material was available with the prosecution at the time of arrest to connect the respondent with the allegation level against them of indulging in drug trafficking. It has not been denied by the prosecution that except for the respondent in so-and-so, none of the other respondents were found to be in possession of commercial quantities of psychotropic substance as contemplated under NDPS Act. Then next paragraph, it's the ratio laid down in Tufan Singh has been reiterated. Accordingly, they have been fixed. Now here in my case also, so far as the documents supplied to me, none of the witnesses examined under section 161 has implicates me. And out of blue, the police officer comes, saying to be me to be a suspected accused, arrest me somewhere, in Sarupathar, and then got my statement recorded, implicating myself. And the ground of arrest, your lordship will find the forwarding report at page 23. Relevant In the body of the forwarding report, nothing is there, but ground of arrest, what they are saying at page 24. Regarding matter, the first matter, during the investigation, available evidences found against the arrested accused person, as I said, nothing. Matter. Then Lordship may come to serial number 5. The accused person, along with others absconding, accused Riaz Ali went to the hotel Bharat at Dimapur, where the previously arrested accused persons Sadan Gogoi and Sandan Bora met Raju Banerjee and Riaz Ali, who supplied a heroin to them. Now, this is absolutely absurd. The receptionist and the hotel personnel have been interrogated. Their statements are recorded. The documents have been seized by the police. None of the persons has said stay of the present petitioner. It is only the Riaz Ali, not me. Nobody has said. Riaz Ali stayed with the arrested accused, the Sadhan Gogoi and the other one. Then 6. Absconding accused Riaz Ali provided his voter ID card as a proof of identity, and Raju Banerjee provided his mobile number so-and-so to the hotel authority. It's absolutely absent in the statement of all those matters. The mobile number 60 so-and-so was in the use of IME, which has been seized from the arrested accused Raju Ali. I do not know whether it belongs to him or not, because I have not been given the seizure list also. If you be the best person to say whether it is available or not. So these are the only things for which at the police own volition or own suspicion that I am involved, I have been arrested. Already 208 days have been gone. Therefore, I am praying that he should be released on bail. And so far as the prosecution also, the evidence have not commenced as yet.
No further. May I please, Your Lordship? Petitioner in this case is, Your Lordship, the same case, Your Lordship, accused person. He was arrested on 289 days. He was arrested and retained in custody for 289 days, Your Lordship. His name is Vikas Gogoi, Your Lordship. In fact, from him also, Your Lordship, no drugs has been seized, substance has been seized, Your Lordship. And he was, FIR also did not name him, Your Lordship. But Your Lordship, subsequently, on the basis of Your Lordship statement of co-accused, Your Lordship, 2 of the co-accused, he was arrested and behind bars. Going by the Your Lordship, the statement and the what they have found, Your Lordship, that I finance the business. That's what they say, Your Lordship. And interestingly, Your Lordship will find from the search sheet, Your Lordship, that only that is there, Your Lordship. But so far as I am concerned, Your Lordship, no bank account, nothing has been seized, Your Lordship, to show that I have finance in any way, Your Lordship. And as Your Lordship, learned senior counsel has submitted from 2 judgments, Your Lordship, to Pan Singh, and I would not go again, Your Lordship. The statement of these co-accused, Your Lordship, accused persons cannot be basis of the conviction ultimately, except that, Your Lordship, there is no material at all, Your Lordship, against the petitioner, Your Lordship. Saying that, Your Lordship will find, Your Lordship, if Your Lordship go through the record, then Your Lordship, one Sadhan Gogoi, Your Lordship, he is one of the accused. He says that, Your Lordship, in his statement, he stated that on 3/6/2024, he was asked by Jamai means the petitioner, to bring him a car for him. Accordingly, a friend of Jamai brought a Bolero and handed over to him at Tipling under Duliajan PS, Your Lordship. Except that, Your Lordship, there is no other material. This line only, Your Lordship. And another person, Your Lordship, he is also, Your Lordship, an accused, Chandan Bora. He has also stated that গাড়ীখন বিক্ৰী কৰাৰ বাবে লৈ আহিবলৈ কয়, মই গাড়ীখনত ড্ৰাগছ আছে বুলি জনা নাছিলো, গাড়ীখন আনি দিয়াৰ নামত জামাই নামৰ ল'ৰাজনে 10,000 টকা দিছে. Now these are the 2 statements, Your Lordship, but Your Lordship will kindly see, apart from the statement of these co-accused and this my statement, Your Lordship, there is nothing more than that, Your Lordship. Whether this will ultimately lead to conviction or not, Your Lordship, that's an issue
And your lordship has seen from those two judgment, your lordship, that cannot be the basis of conviction, your lordship. And in the meanwhile, your lordship, 9 days has been, he was in custody, your lordship. Apart from that, your lordship, that point also need to be seen, your lordship, by instruction, your lordship, that the ground of arrest has also not been provided to him, your lordship. That's the record will reveal, your lordship. This much, your lordship.
I take up the my lord first bail application, my lord, that is item number 21, Raju Banerjee, my lord. My lord, my learned senior friend has already read, my lord, page number 25, the forwarding report, my lord. So there are specific, my lord, because admittedly, my lord, this case has been registered, my lord, under section 21C and section 29 of the NDPS Act, my lord. And the, my lord, contraband recovered is a commercial quantity, my lord, and it is recovered from two persons, my lord. One is Chandan Bora, another is Sadhan Gogoi, my lord. And the contraband is, my lord, 425 gram heroin, my lord. Now, my lord, 31/10/2024 charges submitted, my lord. Thereafter, 16/11/2024 cognizance taken. Then on 27/12/2024 search claim, my lord. 27/12/2024. And now the case was fixed on 21/2/2025 for evidence, my lord. Although my lord, witnesses have not turned up, my lord, that is why, my lord, the proceedings of witnesses could not be examined, my lord. Now, my lord, lordship may kindly come to page number 24, my lord. Lordship will see. My lord, these are grounds of arrest, my lord. Page number, point number 5, my lord. The accused person, along with the other absconding accused, Riaz Ali, went to the Hotel Bharat at Dimapur, where the previously arrested accused person, Sadhan Gogoi and Chandan Bora, from whose possession, my lord, contraband was recovered, met Raju Banerjee and Riaz Ali, who supplied heroin to them, my lord. Although, my lord, it is a co-accused statement, my lord, Tufan Singh has clarified, my lord, on the basis of co-accused statement, my lord, person cannot be convicted, even it is applicable at the time of bail also, my lord. But during investigation, my lord, the co-accused statement has to be relied on, my lord. Because, my lord, contraband recovered, which is commercial in nature, from two persons. Now, the next question will be, my lord, who supplied them the contraband, my lord? So, my lord, after, my lord, taking the, my lord, contraband, the police has to go further, my lord. Because the next question will be, my lord, who furnished, who supplied them the contraband, my lord. Now, for that purpose, my lord, they were interrogated, and these are the materials, my lord, police has found, my lord. After that, my lord, the absconding accused Riaz Ali provided his voter ID card as a proof of identity, and Raju Banerjee provided his mobile number so and so to the hotel authority, where, my lord, the drugs was handed over, my lord. The mobile number so and so was in use of IMEI number, IMEI number so and so, which has been seized from the arrested accused Raju Banerjee. My lord, this is very important, my lord. The accused person had frequent contact with the previously accused person Sadhan Gogoi and Chandan Bora, and he confessed that he supplied heroin to them in the Hotel Bharat Dimapur. The mastermind Riaz Ali and entire gang behind the supply of drugs cannot be arrested unless accused Raju Banerjee is not arrested. So, my lord, yes, my lord, they were this accused person Raju Banerjee and Vikas Gogoi were arrested, my lord, on the basis of co-accused statement, my lord. Although no recovery has been made from them. But, my lord, what they have done, they supplied, my lord, Raju Banerjee supplied. And Vikas Gogoi, my lord, he planned the entire thing, my lord. He arranged the vehicle, my lord. He has arranged the meeting, my lord. The Sadhan Gogoi and Chandan Bora, along with Raju Banerjee in the hotel, my lord. So he is the main mastermind, my lord, who has, my lord, organized the everything, my lord, including, my lord, meeting of the person, my lord, by providing the vehicle to carry the contraband, my lord, because they went to Dimapur in another vehicle, my lord. And that vehicle, my lord, which was seized, my lord, along with the contraband, that was the different vehicle, my lord. So this Vikas Gogoi, my lord, this item number 22, my lord, he is the mastermind, my lord. So at this stage, my lord, I am opposing, my lord, since the charge has already been framed, my lord. And regarding 47 notice, my lord, that I have to verify, my lord, because I could not go through, my lord, the entire scan copy, my lord. It is a voluminous, my lord. So, my lord, that I have to peruse, my lord. Whether 47 notice, my lord, it is mentioned or ground of arrest has been mentioned or not. Otherwise, my lord, as far as the materials are concerned, my lord, there are sufficient materials collected, my lord. Although, my lord, they were arrested on the basis of quick statement, my lord, but forwarding reports specifically stated, my lord. What are the, my lord? What are their involvement, my lord? The first person, my lord, the Raju Banerjee and Vikas Gogoi, my lord, they have organized everything, my lord, and Raju Banerjee supplied the, my lord, contraband. This is my humble submission, my lord. At this stage, I oppose this bail application, both the bail applications.
Regarding item number 20, my specific case that none of the witnesses examined has implicated me.
Witnesses are not yet examined, my lord.
Then where from this forwarding report this statement comes? Unless witnesses says while forwarding me where from this the grounds comes.
The co-accused is implicated.
And now charge sheet has been submitted. Now he is saying that witnesses are not yet examined.
So witnesses are not yet examined. These are the statements of
the-
161.
161, I'm referring to 161, not evidence has not taken place. Let him show from the 161 statement, any of them has implicated me. It is only the police statement, but he is not a witness. In the list of witnesses, the police officer, investigating
severe-
officer, he has not said that it is my personal knowledge, I know in this way. None of the witnesses have said, madam. That's what my categorical statement. And regarding my seizure of the phone, also I have said, madam, that the seizure list has not been furnished to me while I appeared before the court and the documents were given to me. It might be there indeed, but that has also not been pointed out by the council.
Even there are severe analysis, my lord, where from, my lord, it has come, my lord. The accused person, Raju Banerjee, who was in constant touch with the, my lord, other two accused persons, my lord, from whose position contraband was recovered, my lord. My lord, these are the, my lord,
Whose
privacy
statement is
materials,
this,
my
my
lord.
lord? Whose statement, my lord? The police officer's statement or the
It has come during investigation,
PP's
my lord.
statement, my lord?
No, it has come during, I am submitted.
During investigation only it will come through some of the witnesses or some documents. It is not from the personal knowledge of the police officer. That's what I have been saying, my lord. No, he has not pointed out any of the witnesses who connected me with the offense. And I can read out, my lord, 3-4 persons from the hotel whose statements are recorded. None of have revealed my name. How this police officer got his name, my lord? So therefore, my lord, it's a whole, my lord, absolutely malafide, just, my lord, implicated me without having any, my lord, material. And in the GD entry, I have again pointed out to your lordship, my lord. My statement has been recorded, my lord, implicating self, my lord, in the conference. That is the only statement and the entire, my lord, record. And on that basis, I have been, my lord, there more than 6 months, 7 months rather. And they are trying to proceed, my lord, to convict me under with those, my lord, material. Not sustainable at all.
Lordship, I just want to point out, your lordship, two things, your lordship. First of all, your lordship, learned PP has been arguing as if we are seeking bail at the stage of investigation. That is not the case, your lordship. At the investigation stage, yes, co-accused statement can be, your lordship, relied on, then your lordship, investigation can be carried out. But that stage is over. Now we are in the stage of trial. At this stage, this has no value, your lordship, as per the law. He has admitted it, your lordship. In spite of admitting that, referring to the part of investigation, stage of investigation, there is no meaning to that, your lordship. And your lordship will kindly see in my petition, your lordship, this is the charge sheet, your lordship, at page 21A, your lordship.
That is the statement. No, that is the also statement.
This is
Page number?
Your
Page-
lordship will kindly see, this is how they have
Page number?
page 21A onward, Annexure C, your lordship, last annex. Now, your lordship, the Honorable Apex Court has said, your lordship, I can provide the judgment, your lordship, that what used to be there in the search sheet, your lordship, specific role, specific act attributed to the accused, that should also be there, your lordship. Your lordship will see the manner in which search sheet has been prepared, your lordship. Page 1, then the particulars of the accused person search sheeted. Then up to 22, your lordship. Your lordship, no, nothing is there, your lordship. What role? In fact, your lordship, they themselves know that at this stage they cannot rely on the statements of the co-accused, your lordship, as per the Tufan Singh, your lordship. Therefore, they have not come up with the specific facts, your lordship. So, your lordship, ultimately, your lordship will have to see, your lordship, whether based on these statements I can be convicted or not, your lordship. If not, the end of the matter, your lordship, I am entitled to bail, your lordship. And secondly, your lordship will kindly also verify that whether your lordship ground of arrest has been served on me or not, your lordship. These are the submissions.
Regarding conspiracy, my lord, it is very much difficult to prove the conspiracy, my lord. Against each and every person, my lord. That, my lord, Supreme Court has also relied on, my lord. Because in case of conspiracy, my lord, direct evidence is very much difficult, my lord. But what, my lord, the investigation has found so far, my lord, and before submitting charges, my lord, there is sufficient material, my lord, as far as this Vikas Gogoi is concerned, my lord. He is the mastermind, my lord. He arranged everything, my lord. He arranged the, my lord, contraband. He arranged the person who will provide the contraband. He has given the phone number of that person. He has arranged the hotel where this person will be meet, my lord, and where the contraband will be supplied. Even, my lord, the vehicle was changed, my lord. They went to Dimapur in another vehicle. They came from Dimapur in another vehicle along with the contraband, my lord. This is everything has been done by this Vikas Gogoi.
I was not, your lordship,
That is why section 29
arrested,
is
your
there,
lordship,
my lord.
and your lordship, we are not
Section
seeking
29 is
quashing
there,
of
that
the
is why.
FIR, your lordship. Then, your lordship, this 120B, etc. will come, your lordship. We are not seeking quashing of the FIR, your lordship, conspiracy. Trial will even otherwise also go on. Your lordship is only considering the bail, your lordship.
Dispose of, man.
Deeply aware.
Dispose of, man.
Right. So high level of this. How many pages left? There are the, some of them. 35.
35, Your Lordship. Without my consent, that matter was mentioned. It is order has already been passed, so I'm not pressing on that. I just pray, my lord, a fixed date may be given.
May not be possible. May not be possible.
My lord,
After 2 weeks, it has been listed. If I make a mention before
it
the
is a
race
long
date, sorry.
pending matter, my lord, and it has been, I've been trying to list it.
So
for-
we don't have any, in fact, we don't have any dates, prior Bihu, after Bihu also. That is, our problem, we have some other problem. It is not so be a long date, is we have fixed it after 2 weeks only. You make a mention before AST and it will be listed.
God bless you.
23.
May I please, your lordships?
Yes.
My lord, despite remainder my scan copy has not yet been received, my lord. This is the
Not
matter-
yet received.
Not yet received, my lord. Remainder was also issued, my lord. And this is happening in the post below, my lord. On the same stage, my lord, evidence stage. From the month of August, the case is still pending, my lord. Not
In
a
the
single
district
sum
says
of-
that's Kamrup 5.
Yes, my lord. Not a single witness has turned up. Even no someone was served. And that is why I have came before your lordship, my lord. More than 1 year, 2 months, my lord.
Case is under which case?
My lord, 22C, my lord, NDPS commercial
Commercial
quantity,
quantity.
my lord. I am the driver, my lord. And vehicle is not belongs to me, my lord. And nothing recovered from my possession.
Okay, we'll make a strict direction to the registry to may issue a reminder. If necessary, then definitely show cause will be also issued to the learned counsel court below. Why from Kamrup Metro the case diary, I mean case record is not available?
My lord, absolutely.
Your petition, I don't know since when, but your petition is pending. First date was fixed on 7/3 only.
Yes,
And therefore next date is 19/3.
Yes.
I don't think, is there any other dates here?
No, my lord.
Ah.
My lord, the trial is pending
Hmm.
at the same stage of evidence.
No, no,
from the
okay,
matter.
trial is pending
Yes, ma'am.
because no evidence is recorded
Yes,
since
ma'am.
long, that is understood. Now, but here to case was first listed on 7/3.
Yes, my lord.
7/3, most probably record was called for, it has not come, and then we are issuing reminder on 19/3
19.
also.
Yes, ma'am.
So today, kiman time?
Today is 26.
26.
19 days.
But anyway, from
Yes,
Kamrup Metro, it
yes,
has
yes.
to come, yes, in fact. Okay, you, Mr. J.H.
J.H.
Saikia, heard
Yes.
Mr. J.H. Saikia, the learned counsel for the petition. From the office note dated. K. Bosha Lekik. K. Bosha, sorry, K. Bosha Lekik. And from the office note dated 24/3/2025, it is in the scan copy of the trial court record is not yet received. In spite of issuance of reminder, accordingly, the registry is hereby directed to do needful and to issue reminder to the learned trial court below with a direction to furnish the scan copy of the LCR on or before the next date of listing. Strictly on or before the next date of listing. Sorry, positively on or before the next date of listing. But it will be listed after Bihu only. Prior Bihu, we don't have any dates. Prior Bihu, we don't have any dates. After Bihu only. Yes, we can. We're listing it on
7, 8,
25.
any date, my lord.
No date, we don't have any dates. 7 is 20? 25. We're listing it on 25. Expecting
Alright.
that to come.
25.
Let's see your lordship. FIR, your lordship will find at page 13. Your lordship, 36.51 gram of, along with soap case, lordship, that heroin was recovered. And the net, and the without soap case, lordship, the weight of the contraband is 10.54 grams. 10.54 grams without soap case, and that is intermediate quantity, lordship. And he is in custody since lordship 7/2/2025. That is as on today, 48 days in custody, lordship. At this stage, my submission for lordship is that considering the detention period and the lordship, his age and there is no other criminal antecedents, lordship. Considering that aspects, will maybe consider lordship, as the rigors of section 37 is not applicable in the present case, lordship.
Intermediate quantity, my lord, is from his possession, my lord. And it is pending to collect the FSL report, my lord. That is clear.
FSL report.
Otherwise, my lord, is from his possession.
Detention period that is already 48 days, that may be.
10.54 gram heroin, my lord, it's intermediate quantity.
Intermediate. Heard Mr. A. Ahmed, the learned counsel for the petitioner. And also heard Mr. R.J. Burga, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD received, first December, on both sides. Next point, Mr. Ahmed, the learned counsel for the petitioner, submitted in this regard that as per the FIR, the recovery, the contraband was, no, as per allegation, sorry. It is submitted that the the contraband which was alleged to have been recovered is only 10.54 grams, which is an intermediate quantity. And the present petitioner is behind the bar since 7/2/2025. And thus he is in custody since last 48 days. He further submitted that the present petitioner has no other criminal antecedent. And and accordingly, considering the length of detention, the petitioner may be released on bail. However, he is ready and willing to cooperate the IO in further investigation of this case. Next para, Mr. Burwa, the learned additional PP submitted in this regard that from the materials available in the case diary, it is seen that contraband was recovered from the conscious possession of the present accused petitioner, which is 10.54 grams, that is in intermediate quantity. The further it is seen further from the further he submitted that the FSL report is yet to be collected by the IO, though the contraband has already been sent for examination. Next para. Mr. Ahmed's submission, Avata Divo. Mr. Ahmed's submission that Mr. Ahmed further submitted that as it is a case of intermediate quantity, the record of section 37 will not follow in this case. Next para, considering the entire submission made by the counsel for both sides, without going into detail of the merit of the case, considering the length of detention, I find it a case to enlarge the accusation, so and so forth. We know whose was satisfaction?
That is, Lordship, Judicial Magistrate First Class Boko Kamru.
No, Judicial Magistrate Boko Kamru?
Yes.
Also intermediate quantity.
Production is done before that for intermediate quantity.
There are some in some courts, the intermediate or small quantity are tried by the even. So otherwise, the special judge is there.
Yes.
So I don't know which satisfaction will be difficult then.
So this is in the investigation stage, my lord.
Lordship, observe that to the satisfaction of Special Judge Kamru Paminga. I will furnish to him, and if required, he will send it to the.
No, otherwise, as per the commercial quantity, whenever it is a commercial quantity, directly comes before the special judge.
Yes.
Some kind of investigation or first remand, second remand may be there from the Magistrate First Class, but otherwise it before the special judge. But there are some observation that intermediate quantity or the small quantity may also tried by the First Class. So I don't know where it is because it may create again problem.
Because
So
forwarding report, your Lordship, page 17, it is before Judicial Magistrate First Class Boko Kamru.
Boko Kamru.
Yes.
Let it be then, yes,
Before
trial.
session judgment. Even in the small quantity also, my lord, trial will be before the session judgment.
Intermediate quantity, Lordship, that trial will be probably before the special judge.
Special judge.
Special judgment.
No, as I'm saying that because you should not come for any alteration there. That's why I'm just speaking that. Then okay, then special judge Kamru
Paminga.
Aminga. To the satisfaction. Okay.
Problem.
Twenty-six.
26 case diary not received, my lord.
Please, your lordship. Lordship, it's a 483 application. Petitioners are behind bars for last 20 days. It's been 20 days, lordship, and the main accused lordship has already granted bail.
No, he is saying that CD is not received.
Lordship, in the last occasion, lordship has his opinion that has short date may be fixed. They're the driver and Hedney bail, and lordship has enlarged bail to the main accused, the owner of the disputed rice, lordship. So that is the factual position of the lordship. May peruse the order passed by your lordship. It's been 20 days. What purpose would serve lordship keeping them in custody? Because the main main accused has been granted the privilege, lordship, of pre-arrest bail. So may I pray, lordship, that the poor person daily wage earner, lordship,
No, we don't know,
The-
this is
they-
your,
Lordship,
the person, just a second, the person who was granted with bail was the owner of the
Rice.
rice and truck and all.
Rice.
So he was, after considering your submission, he was granted
Yes,
with interim
Lodge.
protection.
Lodge.
So fixed date is, most probably next date is on 24/4.
For Lodge.
24/4,
my-
yes.
My respectful submission, Lordship. Here, rice has been seized, truck has been seized. All documents are in question, has to be answered by the owner, Lordship. They are as per the dictate of the owner, Master Lordship. They was driving. I have categorically stated. And even the record also here, materials also reflect that these two persons are none other than they are the driver and handyman, Lordship. And they are at the instruction of their master, Lordship, they are driving, and that has been intercepted. That is my case, Lordship.
Yes.
So, Lordship, may I pray, Lordship, considering all facts, Lordship, may grant them the privilege of regular bail. They are in custody for last 20 days, Lordship. It's not they are praying for pre-arrest bail, Lordship. They have been detained for 20 days,
So
Lordship.
what I remember, my lord, the
Yes,
person, my lord, who was granted interim bail, my lord, he produced the, my lord, he produced before the honorable court, my lord, bill of, my lord, purchasing the rice, my lord. Because at that time, my lord, where this vehicle was intercepted along the rice, my lord, they could not produce any documents, my lord. Now the owner has appeared before this honorable, owner has approached this honorable court, my lord, with a pre-arrest bail application. So to cooperate with the investigation, my lord, he was granted interim protection, my lord, so that he can appear before the police investigating officer and produce the relevant documents, my lord. That is why, my lord, he was given interim protection, my lord. Now, from the as far as these driver and handymen are concerned, my lord, they were arrested because they could not produce any documents while the, my lord, the truck was, my lord, intercepted and, my lord, rice was seized, my lord. This is my humble submission, my lord.
That is the case, Lordship.
And today is the second day, my lord, that we have not received the case diary.
That is the case, my lord. Considering the length of detention, maybe
But her contention is that, the driver and handy, they were carrying the rice bag in their truck. They said truck was intercepted and as they failed to produce the documents, it is admitted they failed to produce the documents, so they got apprehended or arrested in connection with this case. Subsequently, the picture came to this, it was known to the owner and he came and produced some documents and we already released him, granted him interim bail. So that is the case otherwise.
That is the case, ma'am.
Okay. Heard MS T. Som, the learned counsel for the petitioner, and also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. This is an application, section so and so, in connection so and so, CD not received. CD not received. As submitted by Mr. Borwa. Next for that. In this context, Mr. MS Som, the counsel for the petitioner, submitted that both the petitioners are the driver and handyman of the vehicle, and they are not involved in any involved in the case, and they are not they have not committed any such offense as alleged in the FIR. It is a fact that on the direction of their owner of truck oblique rice, the contraband was the material was carried in their truck, and as they could not produce any relevant documents at the time of interception, they were apprehended by police, and since last 20 days, they are in custody. In the further, she submitted that the owner of the truck oblique rice bags are already granted with the interim pre-arrest bail with a direction to produce all relevant documents before the arresting authority, and hence
To verify and examine.
to verify and examine the documents, and hence further custodial detention, interrogation of the present petitioner may not be required in the interest of the investigation. However, they are ready and willing to cooperate the IO in further investigation of this case, so and so, so and so. Next paragraph, Mr. Borwa submitted in this regard that the owner of the rice bag and truck of rice bag was granted with interim protection as he produced some documents before the court on the day of hearing with a direction to appear before the IO and to produce all the documents so that it can be verified by the investigating authority. But it admittedly, these two accused petitioners could not produce any relevant document at the time of interception of the truck, and hence, and accordingly, he submitted that without going by the materials in the case diary, he may not be in a position to submit more in regards to the merits of the case. Mr. Borba accordingly raised objection and submitted that CD may be required before granting the order of it. Considering the entire submission made by learning council for both sides. And it is also seen that by order dated 19/3/2025, this court had granted the interim pre-arrest bail to the petitioner, who is the owner of the rice bags which were seized in connection with this case, who appeared before the court with some relevant copies of some relevant document. Considering the entire aspects of the case, the role of the present two petitioners, I find that further custodial interrogation may not be required for the interest of the investigation. To whose satisfaction this test will be?
CGM Kandapla.
CGM Kandapla. Okay.
And deeply obliged. Deeply obliged.
May I please the lordship? Regular bail application, FIR is on page 15, lordship.
Page?
15, lordship. 1 plus. One person is named in the FIR and he is arrested, lordship. And allegation is that lordship recovery of 32.18 gram of suspected heroin and 6.48 kg of suspected ganja. And lordship, this person was arrested and I am not named in the FIR. I was arrested later on. Lordship, on the basis of the alleged statement of the accused person that ganja was brought from me and another one person. I am not involved in the heroin, lordship. And
no, heroin was not recovered from you.
No. The person was arrested, he is named in the FIR. And I am not named in the FIR. I was arrested later on. And on the allegation that ganja 6.48 kg was brought from me and one other person. Both are arrested. And lordship, the amount of heroin, it is discussed in the rejection order, lordship, page 21. That it is inventory prepared before the CGM, lordship, it is 3.7 gram.
Where is the rejection order?
Sir?
Rejection order is at page?
Page 20, lordship. Relevant person is on the page 21. That the inventory prepared before the lunch season not Lakhimpur dated 2/2/25 shows that the total weight of the seized suspected to be heroin is 3.71 grams. This is a small one. And I am lordship in custody for last 49 days.
Otherwise, as per your allegation, what was the quantity of heroin earlier?
Earlier 32.18 grams.
32.18 grams.
Yeah. With container, okay, without container is 3.71 grams, including the weight of the transparent zipper polythene packet. With the polythene packet, also 3.71 grams. And no recovery was made from me.
I was arrested from the forwarding report mentioned accused number 2, Lordship Haribrat Deuri, from the house of Haribrat Deuri. And Lordship, I went to his house to invite them to the wedding of my sister, Lordship. 2 days ago, Lordship, my wedding of my sister solemnized, Lordship. And I was there, Lordship, to invite them to the wedding of my sister, Lordship. I was found there and I was arrested there. I have mentioned in the petition, Lordship.
Yes, board.
32.18 gram heroin and my lord, 6 kilo 480 gram my lord, ganja my lord. That was recovered from the possession of one Abdul Karim my lord. While interrogated my lord, he has implicated this my lord Rajiv Deuri my lord that the contraband my lord, the my lord ganja my lord, it was supplied to him by my lord Rajiv Deuri my lord. That is his allegation.
Supplied by him and along with one other accused, I think, as per him.
Along with another person, my lord. It is the only implication, my lord, by the my lord accused person who has been arrested, my lord, along with that contraband. He has implicated. And today is 49 days, my lord. It is pending to collect the FSR report.
Only to FSR. You are Mr. Bora?
Yes.
Heard Mr. A.K. Bora, the learned counsel for the petition. Oh, H.S.
Yes.
H.S. Bora, the learned counsel for the petition. And also heard Mr. R.J. Borova, so and so. It is an application under section so and so, in connection with so and so. Case diary received, whereas received, heard both side. Next, it is submitted by Mr. Bora, the counsel for the petitioner, that the present accused petitioner is innocent and he is no way connected in the alleged offense, nor there is any reflection, nor he is an FINM accused. However, he got arrested in connection with this case only on the basis of a statement of the co-accused that he along with other co-accused had supplied 6.480 cases of ganja. However, the present petitioner was in no way related in the recovery of the heroin from the other contraband. Next poster. He further submitted that accused is in custody since last 6/2/2025 and thus the IAG got sufficient time for their custodial interrogation. He was arrested solely on the basis of the statement of the co-accused and no recovery was made from his position. However, he is still ready and willing to so and so if he is granted with bail. Next question, Mr. Borova, the learned innocent PP submitted in this regard that as per the materials available in the case diary, the present petitioner along with one used to supply ganja to the co-accused persons and initially the recovery of the heroin was 31 point.
As per the Caesar list, 32.18.
And as per the Caesar list, the recovery, the ganja, the quantity of heroin
32.18 gram, my lord.
Recovered
and 6 kilo 480 gram is the ganja, my lord.
32.18 gram of heroin was also recovered from the person of the co-accused. Mr. Borova further submitted that the FSL report is yet to be collected by the IO, though there is sufficient progress in the investigation. Next para, considering the interest facts and circumstances of this case, without going into detail of the merit of the case, considering the length of detention of 49 days, which had undergone by the accused petitioner, I find that further custodial interrogation may not be necessary for the interest of the investigation. Where it is pending now? Huh? Supreme Court.
Special Judge, NDPS, Lakhimpur at North Lakhimpur.
Special Judge, Lakhimpur, North Lakhimpur.
Yes, NDPS in bracket.
Special Judge, NDPS, Lakhimpur, North Lakhimpur. Case number to that asset. Okay, you continue.
All right.
Regular bail application has on today 17 days, my lord, and mandatory period is 60 days, my lord. CD is called for. FIR is
Case diary not received today, my lord.
My lord, 17 days, and the police has checked my remand, did not stop my remand, my lord. I am in judicial custody. And the allegation is of sexual harassment and 60 days mandatory period, my lord. Actual fact is that now there is a love relations between them, and there.
Here, it was issued, petty heading. We have not made a party. Case is registered under which section?
Case is registered under
Acha,
section.
BNS.
BNS, my lord. There is no POCSO, my lord.
It's a case of sexual harassment.
Yes, 75 to section 70, sexual harassment, my lord. 3 years imprisonment with fine, my lord.
So your period of custody is 17 days.
17 days. I am in judicial
Is
custody.
there any intimation why CD is not received?
My lord, CD was called from my lord, we have also sent acquisition, my lord. But today is the 5 days, my lord. They have not received it.
Issue reminder for you. Issue reminder, and when it can be fixed then? Because he is in custody.
My lord, 9th of April, my lord.
Okay, 9th of April. Well, listing it on 9th of April.
And
We'll
as a
issue
part,
reminder.
my lord, we have some instruction, but we are not sure about it. Whether such sheet was submitted or not, we are not sure about it.
That will inquire, my lord.
That can be inquired, my lord.
You
We are
have
not
any
sure.
instructions?
Yes, but we are not sure about it, my lord. Only instructions. They are also not sure about it, but they only hard, my lord. Maybe such.
But a line of Mr. Hussain further submitted that as per his instruction, the charge sheet has already been filed.
No, that may not be mentioned, my lord. because
But
he-
it
he is
will
not
come
sure.
only.
He is not sure, my lord.
And
But
it
next
will
day
come
will
again,
to-
next week will come, yes. Fine.
And even if charge sheet is submitted, my lord, they can approach the trial court. my
Yes,
lord.
yes.
There is no court.
If it is submitted after filing of this petition and after the calling of the CD, then my lord, I pray for bail for consideration by this honorable court of Supreme. On next date, my lord, a short date may be given, my lord.
9/4 we are giving,
9/4
the
short
day
date.
after, no more short dates, 9/4.
52.
My lord, here, my lord, mandatory period was 90 days. Today is the 91 days. As per my instruction, no application has been filed seeking extension of custody, my lord.
Yes, 4/1, it's a 91 days.
That exercise has to be done before.
Prior.
Prior, my lord. And today is the 91st day, my lord. Any day.
Submit.
Submit.
Yes, my lord, because my lord, what I have been informed, my lord, the case diary was lying before us, my lord. The investigating officer, my lord, he, my lord, requested the public prosecutor to file to file an application for extension of some, my lord, period, my lord, but that could not be, my lord, because the case diary was lying before us, my lord.
No, that could be have been a ground that the case diary is, but we have, without any case diary, we are just submitting for
The
hearing.
request, my lord, I've been informed that, my lord, they have filed it, my lord, but it was not considered or something like that, my lord.
My
My
lord,
lord, he has already completed 90 days, my lord. So this is my humble submission.
My lord,
The
to that
question is
effect-
that suppose if the case diary is lying with us,
My lord.
so you, on that day, most probably you gotten information or whatever that in the meantime, it may fast.
Yes.
But the question is that if it is not filed till today, suppose,
My lord.
maybe case diary may be lying with this, that may be one of the ground, he could have just initiate the process that Padder so request,
the-
but CD we could not
But the
furnish the
problem
CD.
was that, my lord, on the last day before yesterday, but it was already 90 days, my lord. That was the problem, my lord.
Then till that they are not filing.
And
Till today, as per your says, they have not
and
filed.
yesterday they took back the case diary, my lord. But it was already over, my lord, 91.
My lord, I want to put that effect, my lord. CD was called for on 28th of 2. Lordship will kindly peruse the date. On 12 of 3, CD not received. On 24/3, a submission was made on behalf CD not received. But the submission is made that CD was lying here, my lord. I leave it to your lord. Anyways, my lord,
So
mandatory.
CD came before us only on 24th.
Well, but
Prior to that,
Day before yesterday, my lord, no, CD was available day before yesterday, my lord.
only day before yesterday.
prior to that,
Prior
He
to
was
that-
available with us only day before
Day before
yesterday.
yesterday.
So,
But there are, my lord, several cases are pending, my lord, in connection with the same case, my lord.
acha, that may be.
So, my lord, it should be available in connection with some other cases. But the day before yesterday itself, it was already 90 days.
Hmm.
I know. Yes.
You are Mr. T.
Chakraborty.
Chakraborty, the learned counsel for the petitioner. And also heard Mr. Ajay Borwa, the learned additional PP, appearing on the proxy of respondent. So you have returned back the case diary, no?
Yesterday, yes, yesterday took back with the permission of the court, madam. We returned the case. Because there was another matter yesterday. There was another matter, madam, in connection with the same case.
Acha. Submitted that although the case diary was received earlier, but the same had to be returned back to the prosecution as in connection with the other matter pending before the other court. Next one, Mr. Chakraborty submitted in this regard that the statutory period of 90 days has already been over and today is the 91 days. The accused petitioner is behind the bar. Until that, there is no prayer for extension of time for investigation. In that context, Mr. Borwa, the learned additional PP, submitted that the prosecution the investigating officer is in the process of filing, was in the process of filing the application for extension of time for investigation, but to his instruction that has not been filed yet. Till date, next further, considering the entire circumstances of this case, without going into the merit of the other merits of the case, I find that even after a lapse of the statutory period, the investigating officer could not file the charge sheet, nor there was any prayer for extension of time for investigation within the stipulated period. With the observation, it is in the, and accordingly, I find it difficult to enlarge. Where it is to be enlarged?
Special Court NIA.
Special Court NIA. Kamrup? Special Court NIA, Kamrup. This is an application to Kori Divan.
29.
Huh? 29 we have received.
I have already appeared, my lord, interim was there. And both are, my lord, relative, my lord, both the families. So probably the matter has also been settled between the parties.
It was registered under which section?
It was registered under section, my lord, 354B, 7 and 18 of POSCO, my lord. 5 years punishment, my lord.
8 and 17 also.
Yes.
Yes, otherwise, as per his instruction, this client has already been appeared. Yes.
But if I look into the CD lordship on 22/6, again on 5/8, and last is
Just a second, 22,
22
6.
6, 2024. And on 5/8, 2024. And the last date entry lordship, that is. The last date is lordship 15/10, 2024. All of the IO note have stated that he has appeared, it is there, but as a result of his lack of cooperation, his statement under section 161 CRP was not recorded.
So in your case that his statement is still not available.
Still not available, and it is stated that because he is not cooperating, because of that, he cannot record the statements on that date. I have
those dates.
On those dates. IO notice there. He has appeared, my lord, all the time. There is an on yellow instruction from the IO to confess the matter, my lord. That is the problem. Otherwise, every time we have appeared, thrice we have appeared, my lord, before the court, before the my lord, before the IO, and already, my lord, the matter has already been settled between where they are the family members and he happens to be the uncle, and there is some misunderstanding between the parties, my lord. And there is a basically dispute regarding some monetary transaction, my lord. That is why interim was granted. We have annexed all the document also, the previous. And so probably I appear and probably my learned friend is also appearing on behalf of the victim, my lord.
Moreover, 164 statement is there, it is implicating.
In the first, may please your lordship, in the first impression, it was found, the foundation fact is established prima facie. But they, out of court, they came to a settlement, partly for this anticipatory bail application. But my stand before your lordship is that I have said it in my affidavit in opposition and the cancellation of bail petition, your lordship. It is clearly stated about the credible of materials which linking the petitioner to the crime. So since they came to a conclusion only for this bail application out of the court, it is up to your lordship.
No. The question is that you have already filed your affidavit in opposition, whatever.
Yes, your lordship.
Wherein you have, was there any instruction from your client regarding this settlement?
Yes, it is, the instruction is
They have settled.
appropriate, yes. Yes,
But
they have
otherwise,
given.
what is your submission?
Yes, my submission is that, all the statement which I have, my stand only that, the statement about the prima facie of the case, your lordship, that should be taken into account for a logical conclusion of this anticipatory bail application.
That is it. We are not on
Yes.
the trial, my lord. Trial, they will face the consequence, my lord. What will, after the settlement, probably she will agree to the proposition
Yes,
that the matter has been amicably settled. Probably that instruction has been given to
Yes,
her
given
regarding
to-
the settlement of the parties, my lord. Both are, my lord, both the families are very closely related, my lord. And he is also a government servant. And my instruction is because of some dispute.
But it is
my
not
lord.
monetary, it is not monetary, your lordship.
So,
That
my
is-
lord, the interim.
That is a wrong submission before your lordship, but it's not monetary. It is apparently.
That is, may not be wrong, my lord, on my part. That is my instruction. It is your stand. That's a different issue. My instruction was that because of that, some monetary transaction, there may be some misunderstanding. This is allegation as forthcoming because of that. But whatever may be, my lord, I have appeared, interim was granted, I am a government servant, and now they have no objection probably regarding my granting of anticipatory bail, my lord. That what I have got the instruction, my lord, that the matter has been amicably settled between the parties. So
Particularly for this,
yes, I am saying that, my lord.
only for this.
I am
Yeah.
only for the
Yes, your
anticipatory bail. I am not for the quashing of the FIR here. I am only for the
It
anticipatory
is
bail.
not the jurisdiction also, your lordship.
So,
for
So
questioning
I am saying that regarding the anticipatory bail, considering the future of the outcome of as there is a settlement and there is no objection to that effect regarding my anticipatory bail, you will face the consequence during the trial, my lord. He has appeared, my
But
lord.
my stand, I have clearly stated in my cancellation petition as well as in the affidavit, so that maybe, if your lordship permit me, I will state I have brought those paragraphs that.
No, your
may-
paragraphs are here also.
Yes, your lordship.
Yes, you pointed out which para you want to suppress.
In my cancellation petition dated 10/9/2024, your lordship, the grounds which I have challenged is at paragraph 2, 3,
That
5,
cancellation,
10,
my lord, after-
12 and 14.
That was not initially they have come up for the cancellation. Now, when there is no objection for the bail, whether the cancellation will remain, my lord.
Your lordship, only on cancellation is on 10/9 and the affidavit opposition is on
You were
13/9.
granted with bail on 26 when? It was
Yes,
granted?
thereafter they have filed a cancellation. Now, my instruction is that the matter has been settled after this. That they have no objection regarding if the bail is granted to me, that is my instruction. I do not know whether that is correct or not. I
The
do not
question
know.
is that at the time of filing the application, when the bail was anticipatory bail was granted, most probably interim, sorry.
Yes,
In that case, you have filed with an application for cancellation of that interim also.
yes.
There was some observation and there was some, you have brought some things, the materials.
Yes.
But those will be there only, and your prime PC, you have submitted the prime PC materials are there. That will remain there, stand.
Yes, yes. That's
Now, 164 statement, now as Mr. Das is submitting, that there are some incremental materials in the 164, that will also be there. These are all the matter of trial, in fact. Now, we are only concerned with the, bail matter only. Now, in this case, you already had the instructions. As Mr. That they have no objection, as the matter some way may not be monetary or it is not us, but there are some settlement. So in that regard, you are not objecting the bail at present. But as Mr. Yes, but Mr. Das, you are saying that in 3 occasions, obviously after obtaining the bail, he appears, but he is not cooperating. But cooperating in the sense why, yes, obviously, but now Mr. Bora is saying that he was asked to, confess. That may not be the approach from the IU also, cannot be confession, may not be there. But the question is that if there is suppose confession is also not there, why the IU could not record his statement? Because he was available before I on 3 occasions. As we have submitted the CD reveals also. Then why?
It is in the IO note, Lordship, that they cannot record the statement because he is not cooperating. I don't know, Lordship, why it is stated there.
Now see, I can deny my desk more weird to Misama Korana. This kind of observation he can
write it. That is enough.
Yes.
But he is in 3 occasions, he has stated the same thing, Lordship. Lordship may peruse there only.
Yes, I have seen.
It is stated there, that I cannot record the 161 because he is not cooperating. How he is appearing, but. My denial could have been recorded, my.
Denial could have been recorded.
It could have.
Not that
Lordship may
he has
reflect
to.
that point and.
Yes, obviously.
Then.
Everything should be in the order sheet, Your Lordship. Those our submissions.
No, generally I do.
Yes, Your Lordship, that's only.
Okay. Heard Mr. A.M. Bora, the learned senior advocate, assisted by you, Mr. S. Nawaz, the counsel for the petitioner, and also heard Mr. K.K. Das, the learned additional PP, appearing on behalf of state respondent, and M.A. Oja, appearing for the respondent number 2. This is an application under section so and so in connection with so and so. CD received, where is the same, heard both sides. It is submitted by Mr. Bora, the learned senior counsel for the petitioner, that after obtaining the interim pre-arrest bail on 13/6/2024, the present accused petitioner, who is also a government servant, is appearing before the IO on 3 occasions, and thus he is cooperating in the investigation of this case. Further, during the pendency of the present application during the pendency of this present application, there was a development and both the parties had arrived at a settlement. And as per his instructions, the parties have, the informant has no objection if the bail is granted or bail is made absolute in view of the said settlement. Next, in this context, Mr. Das, the learned additional PP, submitted that from the statement available in the case, from the materials available in the case diary, it is seen that the victim brought incriminating materials against the present petitioner while recording her statement under section 164 CRPC. However, it is the fact that the accused petitioner had appeared before the IO on 3 occasions, that is on 22/6/2024, 5/8/2024, and 15/10/2024, but the IO could not record his statement under section 161 CRPC as he is not cooperating. Cooperating in the investigation and the IO. Next para. MS Oja, the learned counsel for the appearing for the respondent number 2, also submitted in this regard that there are prima facie materials against the present accused petitioner, and the victim also brought some allegation against the present accused petitioner. Accordingly, the informant also filed their objection, bail objection, which is bail objection against the interim order of bail, interim order of pre-arrest bail. However, she submitted at the stage as per her instructions. The matter has been amicably settled outside the court, and thus the informant raised no objection at this stage, only in respect of bail, isn't it? Next paragraph. Hearing the submission made by learned counsel for both sides, I have also placed the case diary and case diary full stop. From wherefrom it is seen that the statement of the present accused petitioner is not available in the case diary, and the reasons brought by the IO is that he is not cooperating with the investigation, and for which his statement could not be recorded, though he appeared before the IO in 3 occasions. In that, Mr. Bora, the learned senior advocate, submitted in this regard that the accused petitioner is a government servant and he is appearing before the IO as and when he was called for. But কাগজে লিখিছে নেকি আপুনি এবাৰ কাটি দিয়ক না। Next paragraph, but considering the submission made by learned counsel for both sides, and especially considering the fact that both the parties have arrived at an amicable settlement, and in the meantime, in the same time, it is also seen that after obtaining the interim pre-arrest bail, the accused petitioner appeared before the IO in 3 occasions, though it is alleged that his statement could not be recorded due to his non-cooperation. But considering the entire facts and circumstances of this case, I find it a fit case to extend the privilege of bail to the present, privilege of anticipatory bail to the present accused petitioner, and accordingly, the order of interim bail dated interim pre-arrest bail dated 13/6/2024 is hereby made absolute, with a direction to the present accused petitioner to appear before the IO, cooperate him in investigation, and also cooperate the IO to record his statement under section 161 CRPC. So we will suppose even after that order, he is directed to appear and to record his statement. Suppose in spite of that, you have the opportunity to make the prayer for bail objection also. Suppose during that period, if he doesn't appear and not cooperating. Otherwise, it can be a ground for cancellation of bail also. Otherwise, we have granted with bail.
Yes. There is a request, humble request, Your Lordship. Due to the matter already fixed at the item number is 51 motion, there is an urgency in another matter along with that.
Okay, we'll sit it.
Okay, thank you.
Except to us.
Except to item 51.
May it please your lordship, my lord. This is a pre-arrest bail application, my lord. Your lordship will find the credentials of the petitioner at paragraph number 2 in the bail application at page 3.
Yes.
My lord, paragraph number 2, I have given the credentials of the petitioner, my lord. He is one of the top scientists of the world, my lord, in his field. Even the Stanford University has ranked him as among the top 2% of the scientists. Now he works in the CSI in Jorhat, Assam. Now, as a scientist, my lord, when there is something required in the laboratory, or the students or the research fellows, they want some products, then, my lord, the indent is placed. Then the indent has to go to the purchase department, finance department, the stores will receive the products. So far, the role of the petitioner in the purchase procedure is only that he gives the
indent, and he has no authority so far to influence the supply or the quality checks or payment processing. I have given the entire procurement process of CSR NIST at paragraph number 4. Basically, the gist of the procedure is that there are separate finance department, stores department, and my lord, goods are checked at the point of delivery. And so far the present petitioner is concerned, his role is only a procedural role. Now, so far the FIR is concerned, your lordship will find at page 33 the FIR starts, but your lordship will kindly take note of 2 dates, my lord. As per the form of the FIR, the occurrence took place on 22/2/2024. 22nd of February 2024. And my lord, the FIR was registered on 25th of May 2024. And my lord, the charge of the house of the petitioner was conducted on 19/3/2025. And my lord, during the charge, except his mobile phone and some documents in relating to his credential, nothing incriminating as such was recovered, nor it is a case of any disproportionate recovery of materials or anything. Now, the typed copy of the FIR is at page 33. Before I take your losses to the FIR, my lord, basically the allegation in the FIR is that for extraneous consideration with one purchaser, my lord, the allegation against the scientist is that he has taken a iPhone 15 and a laptop, but during the charge and seizure procedure or those things were not recovered. Your lordship will find that FIR at page 33. So basically, my lord, what I find from the FIR, that the whole case is based on documentary evidence and some of the documents have already been seized. As on date, my lord, so far petitioner is concerned, he is willing to cooperate with the investigation as he has cooperated all along during this time. So at present, my lord, till the case diary comes, my lord, I respectfully pray that his custodial detention may not be required because, my lord, he was initially given a summon to appear before the court. He came to Guwahati while he was in conversation with us. My lord, he had suffered a minor accident. My lord, we have given the medical certificates and all. Now the CBI has again asked him to appear on 25/3/2025 at 10 AM in their head office. Earlier also appeared during the charge. Also, I was present. I had not absconded. I am willing to go and appear before the investigating officer. But since, my lord, I am a person, only an academician, if already my reputation after the lodging of the FIR, because they have alleged that I have taken a mobile phone or a laptop, my lord, my reputation has been harmed. So, my lord, if I am detained, my lord, your lordship knows only that I will be immediately placed under suspension, or I don't know the intent behind this issuance of this notice, my lord. This is after the filing of the bail petition, they have asked me to appear. They had asked me to appear yesterday after the filing. This bail petition was filed on 24th. And this notice, my lord, I received it later on. It was dated 23. I received it later on, my lord, after the filing of this bail petition. So today I am praying that only for a duration till I go and appear before the CBI. Let them interrogate me. I will fully cooperate with the investigation. Considering the nature of the allegations made, my custodial detention at this stage may not be necessary. That's my respectful submission before your lordship, my lord. And central government employee, scientist, as a family.
How he used to that the tender and Indian tender and all from his office.
No. What we have to do, well, suppose in a laboratory, there are some say chemicals are required. So we have only to place the indent to the purchase department, the requirement. The purchase or the department will procure the materials, verify, and the money will be paid by the finance department.
But as per allegation, you took laptop and
A mobile. That's but
from
during
whom?
From the supplier.
One supplier.
Supplier. The accused number 2. But during the house search, on my lord, when the house search was done, of course I didn't knew also at that time that FIR was registered, and my lord, this CBI people searched my house on page 38 to 46. I have given those seizure lists. I was present during the charge and seizure also. They did not take me into the custody. So I do not know, my lord, whether my custodial detention is required by the CBI or not, but at least, my lord, your lordship will protect me for a few days to go and appear before the investigating officer. That I'm willing to do, my lord. I'm not absconded earlier also when they summoned me to their CBI office, my lord.
Lordship, will kindly come to the FIR at page 33 to 11 part. It is not only the laptop or the mobile phone. Lordship will come to the second last paragraph, from the second last paragraph. Information further reveals that on 22/2/24, Dr. Ravindra Kumar Rawal asked Sri Pavan Chandra Bora, he's a supplier, to supply only 50% of the ILS brand items indented in the work order, and further suggested supplying altogether other items. Instead, Sri Pavan Chandra Bora agreed, but suggested to procure at least 30-40% of the ILS brand items, assuring that he would manage the short supply with the ILS brand supplier. Next, for this, an undue advantage of rupees 1.6 lakhs was demanded by Ravindra Kumar Rawal from Sri Pavan Chandra Bora and the supply order for the supply order on 26/4/24. The said amount was delivered on the same day by Sri Pavan Chandra Bora to Ravindra Kumar Rawal. So it is not only laptops and mobile phones. Now, if your lordship will come on what the case is structured, the bail petition is structured on the basis of a document which your lordship will find at page 47. Lordship will see it is a communication dated 21/3/25, second paragraph. In this connection, Dr. Ravindra Kumar Rawal may be directed to join the investigation at 10:30 a.m. on 22/3/25 at the office of the head of branch, CBI, anti-corruption branch, so and so. Now, he was asked to come on the very next day. And what is his plea? He came all the way from Jorhat. He alighted from the bus at ISBT and he suffered a sprain. And lordship will see very interesting. Jorhat bus will arrive Guwahati if it is a night bus by 6 o'clock. Lordship will see the medical document. I'll just show you lordship the medical document. Yes, at page 48. He arrives in the early morning. He was directed to come to the office at 10 a.m. 10:30 a.m. He goes to the hospital at 6:30 p.m. to get a medical certificate. So, the assertion that he makes, I alighted from a bus, I got a sprain, and hence I could not go. He has used the time to make up some plea, because for 12 hours he was all right. Now, why do we say that we are going to, if we wanted to arrest him, we can arrest him. We asked him to come and cooperate with the investigation. That is why we sent him this notice. And lordship will now come to page 53. His contention is, after his purported injury, sprain, if I may say so, the doctor advised him some rest for a few days. Yes, take rest for a few days. I am not objecting to that. When are you going to appear before the authority? The document just now given to my lord is not a part of the record. What he is on is the first document by which he was asked to report on 22nd itself. He has not reported, and in my humble submission, this is, the medical documents is something that he has made up to evade the cooperation that is sought from him. Let him appear before the authority, Lordship, on 30th. I assure this court, Lordship, he will not be arrested on 30th. Let him appear before the court, before the authority.
That's fair enough. Well, since my learned friend has given an undertaking that he
let
will
him
not arrest me
At
on,
least-
I'll go and appear on 30th.
Let him-
my lord. I'll not comment on the certificate issued by the doctor.
But it
I'm
will-
the
it
my
will-
learned friend is fair enough to say that if I go and appear before the investigating officer on 30th, he will not arrest me. Your lordship will fix it up on the I'll be back
Let-
from
let-
Imphal on 2nd, immediately after
Let him
2nd.
let him be on 2nd. In the meantime, Lordship,
No, 2nd not one, third.
let him be on 3rd. In the meantime, I produce the case diary, Lordship, and Lordship will see.
No, he will be appearing on 30th.
30th?
My friend has said that he will not arrest him. When my friend says that he will not arrest him, my lord,
No,
that's a guarantee enough, my lord. I trust my friend, my lord.
No, that is being good enough, but you are
Yes.
trying to make out a case.
Yes, no,
which is
we'll-
not there.
But no,
my
otherwise
lord,
you
your
were
lordship
saying,
is-
Mr. Kumar, otherwise you were saying that you appeared before the IO. On
I
which
was,
date?
my lord,
On which
during the house search and all,
Ah.
I was all along present before the investigating officer. my
During
lord.
her house search?
Yes, ma'am. House search and also in the office when the documents and all were seized. We have mentioned, it's mentioned here, and even if your lordship looks at one document, my lord, which I can show to the investigating authorities also, that is at page 28, annexure 2. Page 28, my lord.
Hmm.
Your lordship will see the chain of command, my lord. Indenter, then project leader, then receiver, then SPA, then deputy SPO, then it goes to the finance, then only department. Yeah.
That is something which will come out. in
Yes,
the
yes, yes.
FIR.
But I'm not,
At
I'm
this,
not.
at
I'm-
this stage, Lordship
Yeah.
will look into the FIR. The FIR discloses a prima facie offense.
No, my lord, I'm undertaken and before this honorable court that I will ask my petitioner to go and appear on before 30th, as my friend has given an undertaking that they will not take him into custody. Your lordship will fix the matter on Wednesday. I think 3rd will be Wednesday. But that undertaking may kindly be recorded, otherwise if you.
That is- No, Lordship,
I'll leave it to your lordship can grant me interim till Wednesday, fix it on Wednesday, then if I have some, material come, you'll put that.
till Wednesday.
So he will be granted with interim, you're saying, or just will direction to appear, assurance and all?
No,
That will be difficult on our part, because let it be in interim,
till Wednesday.
he will till Wednesday.
Yes, yes,
Obviously,
yes.
till Wednesday is the 3rd.
Third. Second,
Second.
third dot corridor. How much,
Oh.
do you take involved? Yeah, do you take a piece of Jikunata date?
Second is
But being a scientist from you, such kind of
Yes,
thing is not
I am also,
expected.
and my lord, I have seen his record.
See,
Yes.
yeah,
Right.
definitely we have a respect from
Yes.
scientists and all.
And my lord, I have seen his record. He is one of the top 2% scientists and recognized by Stanford University. I am quite surprised, my lord. I'll have the proper instruction on the next date also, what exactly transpired, my lord.
Lordship
The lordship
stands
will-
for absolve him of everything.
Yes, my lord. Even the judge will also not be absolved if he is involved in a criminal offense these days. My lord, let it be on 3rd, my lord. 3rd, my lord. 3rd or 4th, 4th to Wednesday, 15th, Friday, 4th.
Hi, Mr. B.D. Kaur, the learned senior advocate, assisted by MS.
S. Jane. Miss S. Jane.
S. Jane. And also heard Mr. K.D. Chaudhary, the deputy LGA for the state respondent. Baki likhibo, this is an application, so and so, so and so. Simple point of, it is submitted by Mr. Wong, the learned senior advocate, that he was all along present during the house search by police and never tried to abscond, and however he is still ready and willing to appear and cooperate with the investigation of this case if he is granted with some interim protection. Mr. R.K.D. Chaudhary, the deputy SDF, submitted in this regard that the prima facie there are materials against the present petitioner. However, he may be directed to appear before the IO and to cooperate in the investigation till the receipt of the case diary, till Wednesday. Or you are going to place the,
Lordship,
Third or
make an
fourth.
observation that he will appear on 30th.
yes,
Yeah.
okay.
Let the
So,
case be fixed
Yes,
on.
I go first further, Mr. Fong assured that his petitioner will appear and appear before the investigating officer on 30th, so and so, and accordingly with the
30th at
What?
11 a.m. also your lordship can fix it.
30 at 11 a.m. before the investigating officer to officer, so and so. To third, we are fixing it on third.
Fourth, my lord, fourth.
Sorry, not third, fourth. No, not fourth, third, I think.
Third.
Is Thursday. Let it be on second, lordship.
The second one.
Okay. I leave it.
Third.
Third, so you are going to appear on 30th.
And on
And
third,
we
I
are
will-
fixing it on third, but third, can we keep fixed on for case diary or you want to any other?
what case diary will
Talk
take?
with the authority.
Ah.
Maybe we'll file an objection also
Oh.
and we'll produce the case diary. lordship.
So interim will be granted till next date of
Third.
third, okay. Fixing it for case diary and the respondent is at liberty to file it objection if any. Okay.
Interim, my lord, granted.
Is interim is there. Interim is there and you were directed to appear on
obliged.
30th on at
Obliged.
11.
Obliged.
Lordship, interim till-
Third.
Yes, sir, till third only,
Third.
till third.
Obliged, your lord.
So for them, they're going to appear before the investigating officer only. Oh. এইটো কিবা লিখি দিম আৰু short কৰি থৈছো ইমান দাবা
30.
Yes, charge sheet submitted, lord.
You are on interim otherwise? Are you on interim?
Oh, yes, lordship.
Interim was there.
Yes, lordship.
CS number, please tell us, CS number
98/25.
98/25,
Dated 28 to
28 to.
2025.
So we are extending your interim till 15 days.
Lordship.
Within 15 days, you may approach the learned trial court below with a regular application. Dispose of it. Okay, it will be
Obliged, lordship.
51.
May I present?
Yes. This time we have received the case diary here.
I have appeared, my lord, in the FIR. There's no direct allegation against me, my lord, because rather against my husband, who was apprehended, my lord, by the authority in the examination hall for possession of two fake, my lord, identity card, admit card by my husband, my lord. And I was granted interim, my lord. I have appeared also prior to and post to the interim order.
Page 22, 23.
I guess my primary.
Where is the FIR? FIR is at page?
Page 14, my lord. He was apprehended, my lord. He was also granted bail, my lord. Sajid Ali is the husband.
You were also appearing exam.
I am also appearing, my husband is also appearing. Before this exam started, he was apprehended, my lord, with a fake identity card. He was actually, he is Sajid Ali, but he is appearing as Sadek Ali. Husband.
Yes, what is
Lordship, it is.
now, as from the FIR, I'm just saying, from the FIR, it's in that her husband was also appearing with a fake identity card. And one line is there's interestingly, sir, his wife so and so, roll number so and so is also appearing in the said examination meeting.
He has been with the roll number in nearby here, our lordship. If she is.
He was
her-
sitting.
Sitting, so that he can help her lordship. And in her statement is also recorded, she has admitted that lordship, but she has asked her not to do this thing, it is there, but he don't listen to him. She has the knowledge, I want to state that, Lordship.
Otherwise, he is working somewhere or for.
He is working as a teacher, Lordship.
Teacher?
But, Lordship, and in this examination, he has applied for 2 identity cards. One real, Lordship. He has a roll number also, admit card also. And for helping her wife, he has made a fake ID, Lordship. Aadhaar card fake.
So against this petitioner, what is any material any?
Accordingly, Lordship, there is nothing as such, but it is only that he has the knowledge that he wanted to
He is
help her.
appearing with his some fake identity.
Uh,
Any custodial interrogation will be required here.
I have appeared, my lord, twice. Twice.
Appeared twice.
Twice appeared. Appeared, Lord. Statements are also there. Main accused is the husband, Lord.
By Mr. A.M. Bora, the non senior advocate, assisted by Mr.
B.A. Chaudhary.
B.A. Chaudhary. V, no,
No,
B.A.
V.
Chaudhary, the counsel for the petitioner, and also had Mr. K.K. Das, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so, CD received, where is the same, hard both side. It is submitted by Mr. Bora, the learned senior advocate for the petitioner, that after obtaining the interim pre-arrest bail on 29/1/2025, he appeared twice before the investigating officer and cooperated in the investigation of this case. Further, he submitted that she is not involved in the alleged offense, though some allegations were brought against her husband, who alleged to have appeared before the examination hall with one fake identity card. However, the petitioner is still ready and willing to cooperate the IO in further investigation of this case if she is granted with the privilege of pre-arrest bail. Mr. Das, the learned additional PP, submitted in this regard that from the materials in the case diary, it reveals that her husband appeared before in the examination with a fake identity card so that he can sit beside her and can help her in the examination. However, he submitted that it also reveals from the case diary that she forbidden her husband not to do such things, but it was within her knowledge but it was within her knowledge.
That he is entering the examination
Yes,
hall
that-
with a fake identity.
Yes, that he is entering the examination hall with a fake identity. Next, considering the submission made by learned counsel for the petition, both sides, matters in the case diary, progress in the investigation, and also cooperation by the present accused petitioner, I find that custodial interrogation is not necessary for the purpose of investigation. In view of this, the interim pre-arrest bill granted on 29/01/2025 is hereby made absolute with the same terms and conditions.
Objection.
Lordship, I am on interim and I have appeared as per the direction of the honorable court before the IO, Lordship.
They have already appeared.
Lordship, there is no
has
direct
already
allegation
appeared,
against
my
me.
lord. Already appeared, two, my lord, only 2 flag marks, my lord. That is horizontal flag marks. Last part, my lord.
So seems that he was in fact used by
My.
in the in,
Only
by- in
his
the
part is that he recommended that person was
Mm.
trapped. My lord, by vigilant.
so it is a case of the MSCP.
Because his name was not included, then he connected with the block elementary education officer. Then thereafter, 1-to-1, he is the last person in the scene who recommended the other headmaster who was trapped by the vigilance and anti-corruption matter. That is the statement. Madam. That is the note of the police. Madam, in this report. Within 7 days, he appeared, madam, because last order, I think, madam, three, and he appeared on 6th.
Yes, any other submission?
Lordship, I recommend because the main accused, Lordship Sushant Nath, he was the secretary of our association, Lordship.
You recommended the name of such Susanta.
Sushant, because he was the secretary of our teachers association, Lordship, and he
What are
forwarded.
the other co-accused? What are the other co-accused? Any other co-accused?
My lord, other co-accused names, many names are there, my lord. There is, my lord,
PO.
my lord, may I read only the relevant part, my lord, from the FIR, my lord. That is, with due respect, I undersigned is assistant teacher of so and so such and such school become eligible for MSCPS modified assured career progress scheme benefits upon 10 benefits the month of December 2000. I again approached the BEO South Siribhumi Education Block and the said purpose and also taken over phone on 6 December so and asked me to approach the grade 4 staff of BEO office, namely Debu Biswas. When I called Debu Biswas, over phone told me to contact Sopan Mondal. Now Sopan Mondal is the, my lord, here the petitioner, and he is the who is a CRCC Cluster Resource Center coordinator. And later I contacted Sopan Mondal on the same day, that is on 6th of December. He told me to approach Sushantana. So this man was trapped, my lord. Sushantana. Apprehended. Sushantana. Now only, my lord, here the thing is that here the informant who was an assistant teacher of another school, and that is the Sushant Nath to whom the reference was made. He is also minor from another school, headmaster of another school.
Lordship, even I'm also one of the candidate of this MSCP scheme. I've also applied, Lordship. And Lordship, at page 25, there was a communication given by Sushanto, this Sushanto Nath, that those who are regular service completed 10, 20, 30 years, as on 1st of January 2025, they can enjoy MSCPS. So therefore, as there is a WhatsApp group, Lordship, therefore I inform the informant that to contact the Sushanto, he can guide you in this regard.
You also applied for MSCP?
Yes.
You are Mr. Purkasta?
Sutradhar, Lordship.
Sutradhar. Heard Mr. S. Sutradhar, the counsel for the petition. And also heard Mr. K.K. Das, the learned additional CP, appearing on behalf of state respondent. This is an application and section so and so in connection with so and so. CD received, bills received, are present. Next para, it is submitted by Mr. Sutradhar, the counsel for the petitioner, that present accused petitioner is innocent and he is the person only who only gave the reference of one Sushanta Devnath who was looking after or was guiding the other person in receiving MSCP. Post of. He himself is the candidate. He also applied for the CRPC. So he also applied for MSCP, who is presently was working as a CRCC. Post. However, after obtaining the interim pre-arrest bail on order of interim pre-arrest bail on 3/3/2025. He appeared before the investigating officer and cooperated in the investigation of this case. Post. His statement is also recorded under section 161 CRPC. Post. He is still ready and willing to cooperate the IO if he is granted with the privilege of pre-arrest bail. Post. Next paragraph. Mr. Das submitted in this context that the present petitioner is cooperating in the investigation and his statement is already recorded under section 161 CRPC. And from the materials available in the case diary, it also reveals that he referred the informant to approach the co-accused one Sushanta Devnath, who was dealing with the matter of MSCP. Next paragraph. Considering the entire circumstances of this case, materials available in the case diary, and the conduct of the accused petitioner, I find that further custodial interrogation may not be required for the present accused petitioner, and accordingly, I find it effective. It was at 3/3/2025. Okay, your order dated 3/3/25 will be hereby made absolute. Appear as and when it is required. CDB returns.
Then item 10.
Maybe by access by 5. Whatever happened, I have also filed one IA also. That does not count also, man. Because some immediately issued for unpayment of the area's maintenance. On the other hand, there is an interim also for stay of the area maintenance, but in spite of that, there are some immediately issue. So against that, I have filed one IA also. That is not come on record. So let it come on another day, therefore tomorrow. I will see that.
No, we don't have days.
Because that
No, why you have filed one IA?
I have a file for, but because the MBW has been filed for non-payment of the areas. Although there is an interim order against
Was there any
It's
interim?
earlier area. Subsequent area, we are not paying.
That is, I don't know, madam.
After 21.
So that is.
No, your interim stay was passed on in 2021.
21.
And there's some
That is
dispute.
for the earlier area. From 21 also, you are not paying anything.
I don't know, that is some dispute is there, madam, regarding that second side there, which.
57,000, madam.
Error amount of maintenance given to the respondent number 2 as on today shall remain state till next day. That part only stay. Now you are paying the regular amount? No, regularly, I mean the monthly maintenance.
Don't know that.
It's not regular.
The regular open also.
You are now see your entire area amount which was due till 2021 that has been stayed or suspended, whatever, this has been stayed. But you are not.
No, I've been told that that amount that during the COVID period, I've been told like that, madam.
No,
So that let the
no, but whatever, but the question is that you are regularly also you are not paying. Leave apart the area maintenance, the other maintenance, the monthly maintenance, that is also not paying by you.
That means I'm going to take instruction.
Then what to say?
That I have
Why
filed.
your
that is not-
NBW will definitely issue against you.
That I have filed, madam, that is.
You have filed your I.
But that is a common record today. That come or in a Monday or.
No, we don't have any dates now. Or Mr. R.A. Chaudhary.
I
Hajarika. I Hajarika, the counsel for the petition. And also heard Mr. A.K. Azad, the counsel for the respondent. It is submitted by Mr. Hajarika that one IA has been filed by the petitioner, which has not come into the record today. And he had to file the IA with them not in the record, and accordingly speed to fix another date so that the IA may be another date be लिखित होगा.
On third, it can be,
মাথা তুলিব সময় নেই।
Fourth, my
Third, fourth, we don't have any, what to do? Say all are praying for third, fourth, fifth, sixth.
filed here last week, my lord. It should have come, my lord.
2021 matter, how our respondent survived, my lord.
No, you already issued NBWA, isn't it?
Yes.
Issued NBWA. Try to
Okay.
get something. You can hear object. It's not a case. It's a maintenance case you cannot avoid, no?
Yes, ma'am, that,
Then issue NBWA. Got arrested him and then do whatever. It will be after 2 weeks, okay. If the
not
registry
too-
finds
too
it.
Long date, my lord. That will be
9 is also full, huh?
next week, my lord, any day.
Okay, give it. Huh? He has filed today, na only?
No, not today. Last week, my lord.
You filed your IR last week. It's not showing.
I don't know, I've not got the file today, so I have to. Last.
Are you
Thursday-
sure you have filed the IR?
Yes, I have.
Yes,
received
You have received a copy.
of
Okay.
it.
চাও বাৰু কি কৰিব কিয় পাই নেকি চাও বাৰু after Bihu will do after Bihu.
He may be.
No, he should be arrested in fact.
Yeah, I will take instruction, what is the position now, that is confirming.
Okay, 9 years. 9. Registry direction টা দিলো নেকি registry এটা তাদের দিয়কচোন registry is hereby directed to tag the IO I with the case record on or before the next date on next date of listing.
May I please your lordship? Lordship senior is election code 14. Matter may taken after something.
I don't know, sometime the other matters will reach, I don't know.
Lordship, even my case is also on legs in court number 17.
Okay, for time being, we are keeping it off. If it reaches only.
Yes. Okay.
Time being, wait, 11 to.
13. May I please?
You are for the petitioner.
Yes,
Other
yes.
side is also their name are showing 4, 5 numbers of
Lordship, as per-
council's name are showing.
Lordship, as per earlier order, we have duly served notice upon the respondent number 1.
Duly served.
We have taken the steps.
No, yes, respondent number 1 has already entered into appearance. Now they are not here. Don't know. Okay, Kabadru Namas, Mr. Suradip Das, A.W. Aman, S. Nawaz, Samir Rahman, all are there for 1. State is a formal party, I think. So whatever they are here, but we can wait for some time. Otherwise, he was here. Mr. Nawaz was all along present here. I don't know why it is gone. Otherwise, you are ready with the hearing or put to the hearing. You are filing.
But Lordship, we have not received the copy of their reply.
Reply. Reply, they have already filed their reply.
Lordship, I am not sure about it, but we have not received till now.
Reply দিছে নেকি? গম নাপাওঁ নহয়। কি হয় reply দিছে নেকি? ক'ত আছে? নাই দিয়া। এইটো গম নাপাওঁ নহয়। এই reply দিছে নেকি? ক'ৰবাত আছে নেকি? হা? অ'। Passover for some time being, then we are not sure. He is not showing, in fact. Or otherwise, you have to fix another date. They were there only. Mr. Nawaz was also here.
He was there in the morning.
Yes, yes, morning hours day he was here. Because they have already entered into appearance. That's what I'm saying. If a hearing is done, then till now, that is not showing that they have filed any objection. If there is no objection, then you can proceed with the hearing only. But they are not present. For the time being?
Yes, Your Lordship.
Okay.
14.
Please, Your Lordship.
Yes.
So this was a petition for the Zimma. As per the order dated, His Lordship just 30/11/23.
30/11.
30/11/23. The very
Ah.
first order. The second last paragraph. A report was called for.
Huh?
relating to the from the IO, Lordship. Right?
Where is the second line? Second para.
Second last para.
Second last para.
As learned additional public prosecutor has appeared. Considering the submissions of the learned senior counsel for the petitioner, learned additional public prosecutor is requested to obtain a report from the IO as regards the status of the seized contraband and his response regarding the prayer of disposing of the contraband by selling the same and keeping the proceeds in treasury during the pendency of trial. So that report is important, Lord.
I have not received any report, Lordship.
Why? Because the order was passed on
Yes, Lordship. A short date may be given.
30/11/2023, in fact. So
I will, short date may be given, Lordship. I will try again, Lordship.
while
But I am
calling for the case report, you also annex the order of disorder. Then only the
Lordship,
I will be.
I will annex the order.
Hearty learned counsel for both the parties. The report which was called for in pursuant to order dated 30/11/2023 has not been received. The additional public prosecutor is hereby asked to make communication with the IO in this regard, and the reminder may be issued along with reminder may be issued, and the copy of order dated 30/11/2023 may be accompanied with the said notice oblique reminder G for error. When it can be listed then, it has to come from which place?
Golokganj, Lordship.
Golokganj.
Dhubri district.
Dhubri.
On 8,
Mr. Chaudhary, it will be only after Bihu. Prior Bihu, we don't have any date. I don't know if it is sale procedure already there in the treasury. It's okay then.
That is what, Lordship. If it is there, then it's fine because these are cough syrups and expiry date also don't.
Also
That
gone.
is what.
But the passing of order of that is a almost 1.5 hour has already gone.
That
So I don't know expiry was date is there or not. Maybe expired by the time. If it is already sale procedure is there in the treasury, it's all right.
That is what, Lordship.
But prior Bihu, we don't have any dates. Can it be after Bihu? Take a date after Bihu only.
Lordship.
Maybe you had a date from the.
Second, 25.
Listing it on 25/4, thus you just communicate with the and we are and you annex the copy of order also on 30/11 passed by the so that we can get the report. If already sale is there and sale procedure has already been kept in the treasury, it's good. Otherwise, so it will be
On 25th.
25th of April.
Deeply obliged.
I'll file objection 3 weeks time may be required.
Huh?
I will file written objection 3 weeks time may be required.
You're going to file written objection?
Yes.
That may not be perhaps required because Lordship, an order under 146(1) is under challenge. That 146(1) is passed without passing an order under 145(1). So therefore, the legality of 146(1) is under challenge.
3 weeks time may be required. I have to collect some documents. I will file written objection.
But on the last occasion, it seems that
Yes,
you
I
have
have to collect. We have already applied, but not collect. That's why.
Lordship, there is urgency
Some
because
urgency.
stay order was operating and then subsequently that was vacated. And now the petitioners got irrigate the peripheral because the stay order was vacated.
Lordship, till that they have not taken a step. They have not even
That
served
is
us
why
the
that was
copy.
vacated.
That's why vacated.
And I did not object in fact. While
Yes, he is vacated, he is operating, but
We file written objection. Lordship. 3 weeks time may be required because I have to collect some documents. That's very essential.
because if your Lordship grants 3 weeks time, then the entire cultivation will be damaged because they could not irrigate. Now the police is restraining the petitioners to irrigate the soil. That is the difficulty here.
Because the documents is very essential. We have to submit it.
And apparently the order is absolutely illegal, Lordship. Because and 146(1) can be passed only when 145(1) is passed. Has to be passed. Here there is no order under 145(1) and subsequently there is no order in the impugn order that there is emergency of breach of peace. These are the two things. So therefore, written objection may not be required.
Is the public property or
It's a private property.
private property?
Yes.
Sorry.
In fact, there is a deed of exchange, which is a registered deed of exchange of 1998 is under challenge. And in fact, the respondent side has filed a civil suit also. for that. And the interim injunction is also pending. No interim order was granted in that civil suit.
Even lordship in this case, Mr. J. Ahmed will appear. He could
And
not-
otherwise also lordship, the entire proceeding has to
And,
go
we have,
because the civil suit,
we have to
they have.
written
already
objection
filed.
lordship. Because some
Civil
documents
suit is still pending.
Yes.
it's a serious week's time may be required lordship.
Heard Mr. Arbora, the learned counsel for the petition. You are Mr.
I am.
I. Ahmed.
I am.
R.A. Ahmed, the counsel for the respondent number. You are 43.
Yes.
There are how many respondents?
Only
Three
one.
respondents, lordship,
That's
the
it.
sub-divisional
That-
magistrate,
that's only one.
the state
Paper
respondents. are
State
there.
respondents.
Yes.
And also heard Mr. K.K.
In fact, the
Das.
objection has to be come from the state side because this SDM has passed the order. And therefore,
State, have you gone through the item number 15?
the order was passed by the SDM. Therefore, if any objection is to be made, that has to be made by the state, not by the private party.
Anyway, state, we have not filed any objection, I think.
What is the objection? What is associated with this case?
Then hardcore, or hard, so and so 1 and 2 representing state respondent 1 and 2. It is submitted by Mr. Ahmed that he needs some more time to file the written objection as he could not obtain some of the documents which were already applied for to file the written, to annex with the written objection. In that context, Mr. Bora, the counsel for the petitioner, submitted that matter is urgent and the stay is operating or stay is not operating. Stays as the stay has already been vacated in this case. Okay, then it will be definitely come after Bihu, Bora. We don't have any date prior to Bihu,
That's why I leave it to you.
and it can be
After Bihu?
after Bihu.
Any day.
Then the one only 28, sorry, 28-4.
Yes.
28-4, enabling the respondent side to file the written objection.
The records have already not received, lordship.
Oh, it was called for?
Yes.
Is it? The registry is also hereby directed to do the needful in calling the scan copy of the LCR, which is not yet received. It is not yet received.
Always, that's all.
See,
Yes.
My lord, this is regarding the.
His government advocate is appearing
Yes.
here. Is
Again.
anyone else available? Yes, doctor. Yes, here government advocate is also here. In fact, for the respond number 2.
Yes.
29 government advocate. Hmm. So no one is here to represent the government side?
Yes, I'm done, my lord. Because circle officer come here, he need to be represented. He
Yes.
was there.
Yes. On the last occasion only, it was sent to.
Yes, it
number
was sent. As per office note dated 23/10/24.
23.
Yes. Yeah. My lord, this is in respect of charge sheet, my lord, there is no prima facie case established out of after filing of the after filing of the charge sheet. So that is why the petitioner filed this petition for quashing of the charge sheet, my lord. This case arose page 14, my lord, if your lordship kindly have a look in respect of affidavit.
The government has to be represented. You have taken steps, but I don't know whether, no,
I have taken steps.
no, yes, yes. The last occasion, actually, order was there.
Yeah.
To, you were directed to serve notice on the government advocate also.
Yes, I have already served the notice.
You have served the
Yes, I
notice.
have served it. To Jagan Handy,
Who? To? Jogan Handy.
Jugan Handy,
Oh, Jugan Handy. কি করব? কি করব?
As per order of the Lordship, Lordship, then if I may be free, then I may call him, Lordship, and may call any other person, Lordship.
Just try to intimate.
Lord-
Just for waiting, we have
Yes.
wait.
May I please know? But in this case, by the impugn order, my prayer for further cross-examination of the witness was rejected. My lord, if Lordship may come to the petition, that is at page 33, my lord. Page 33, my lord. My lord,
This was the petition.
Yes, madam. This is a petition filed under section 138 of Evidence Act, read with section, my lord, 311 of CRPC, my lord, that the accused Sri Man Bahadur Limbu was forwarded before this honorable court on 10/4/2024, and on the same day he was sent to jail Hajot, and subsequently thereto he was never produced physically before this honorable court. That the report reveals that on 27/6/2024, charge under section 6 of POCSO Act was framed, but even on that day also he was not produced physically. All the witnesses were examined in absence of the accused, and even the examination under section 313 CRPC was recorded on 29/10/2024 while he was in judicial custody at Tinsukia jail. The report reveals that the statement under section 313 CRPC is shown to have been recorded on 29/10/2024. However, the signature of the accused is allegedly taken on 30/10/2024 at Tinsukia jail, which is countersigned by the jailer. That the record further reveals that altogether 4 legal aid counsels at different point of time represented the accused, and as per record, the cross-examination of the witness have been carried out by learned advocate Sri so-and-so. That on 3/12/2024, the relatives of the accused handed over the brief of the case to the present advocate, who visited the Tinsukia jail to take instructions from the accused. And during interaction with the accused in the jail Hajot, it is found that he can speak only in Nepali language, and even he cannot speak clearly and properly, and he is aged about 78 years. During interaction, the present advocate took assistance of one convict, namely Sri so-and-so, who is aware of Nepali language, and conversation was made with accused through said Arjun Chhatri. That during interaction, it is found that the earlier advocates failed to bring the actual facts of this case. During cross-examination, the true description of the PO is not brought on record. There was a village meeting on the concocted allegation of the complainant, herein held on 9/5/2024, and in the said meeting, more than 25 persons assembled, and in their presence, the complainant, her family members demanded ₹2 lakh and 1 bigha of land from the accused, and threatened that in failure thereof, they will lodge one case. When the accused failed to concede to the said demand, then on the next day, the instant case was lost. Then, my lord, there are some property demand and all this. Ultimately, my lord, the prayer lordship may come to page 35, my lord. Bottom part, my lord. It is therefore prayed that your honor may be pleased to admit this petition, pass an order for de novo trial for recording the statements of the witnesses in physical presence of the accused, and further be pleased to pass an order for further cross-examination of all the PWs by the accused in this case to meet the ends of justice. My lord, I am not for the de novo trial in this case, and my prayer is only for further cross-examination of the witnesses, my lord. But this petition was rejected, my lord. Lordship may kindly come to the impugn order, that is at page 36, my lord. This is order dated 10/12/2024, my lord. Accused Man Bahadur Limbu is produced from jail Hajot to VC and remanded back till 24/12/2024. Learned defense counsel for the accused files Hajira
heard both sides, DW has not turned up in the petition number so filed under section 311 CRP series section 138 of the Indian Evidence Act by Mon Bahadur Limbu, the accused in this case through advocate so heard learned counsel. And it is stated in the petition that all throughout the trial, the accused is not physically produced before the court, and so the trial is vitiated. Therefore, it is straight to conduct de novo trial in this case. Learned Special PP has vehemently objected this petition. He has submitted that at this big end of the trial, there is no question of de novo trial. This court has carefully gone through the case record. It is revealed that from the record that the trial of this case is duly conducted by engaged defense counsel. It is also revealed that on each and every date, the accused is produced before the court through PC, situated so the facts mentioned in the petition are not found to be tenable when the accused is duly represented by this counsel. There is no question of the accused being prejudiced. Then, my lord, this petition is rejected, my lord. My lord, my submission is that, my lord, he was produced through the VC, my lord. Video conferencing all throughout, my lord. But all throughout he was produced through the VC, my lord. Victim, the petitioner before lordship is aged about 78 years, my lord. He doesn't understand anything about the court proceeding. And my lord, earlier the legal aid counsels are there, my lord. I have made a statement in my petition that they have never met this petitioner, my lord. So they do not know about the actual facts, my lord. And I have annexed the witnesses, my lord, the examination, my lord. In cross-examination, my lord, the important questions were also not put. Put to the, my lord, witnesses, my lord, even the IO, when he was examined, my lord, the contradictions which were in the 164 statement and the evidence that is not put, my lord. The victim was not stated about her age, which school he was reading, what class he was reading, all these suggestions and the informant about the incident and all this and nothing is brought in the cross-examination, my lord. And the person is charged under section 6 of the POCSO Act, my lord, which is although heinous crime, my lord, if he is convicted and the sentence will be life and all this, my lord. So that's why, my lord, I pray that, my lord, one opportunity, I only prayer is to further cross-examination of the witnesses, my lord. I'm not praying more than that, my lord. I'm not praying for de novo trial and all this, my lord. And my lord, one similar.
If you're going to cross-examine all the witnesses, suppose, it will amount to a de novo trial. Only witnesses we have to call for that. That is the case of section 6 POCSO. So it will be delayed as well as, again, it will be considered as a de novo. If all witnesses are to be cross-examined.
Only for further cross-examination, not the evidence.
Yes, further cross-examination, that's
yes, my lord. Because, my lord, if it is de novo, then, my lord, everything has to be start evidence.
Now see all the, how many witnesses were examined?
My lord, total, my lord, 5 witnesses were examined.
Then again, all 5 witnesses have
Yes,
to be
my lord.
called for.
Because, my lord, the important questions and, my lord, similar petitions is one coordinate bench of this honorable court, my lord. In a similar case, my lord, one coordinate bench of this honorable court, my lord, the lordship may take up the criminal petition 1558 of 2024. My lord, similar facts, my lord, may I read the order, my lord? My lord, I'm reading from paragraph 2, my lord, that this application under so this. Then, my lord, paragraph 3, the present petition is facing the trial before the court below. He is in jail and he was earlier represented by the legal aid counsel. Witnesses were examined and the petitioner attempted the trial by video conferencing. The learned trial court agreed with the respondent number 2 and allowed a prayer. 3 prosecution witnesses were examined. After that, the petitioner engaged the personal lawyer. The new lawyer discovered that many relevant questions were not put to the witnesses. Therefore, he filed an application under section 311 of the Code of Criminal Procedure Code, trying to recall those witnesses for further cross-examination by the new counsel. The trial court rejected the said prayer. I have gone through the impugn order, the reason in which the said application was rejected not to be mentioned in the said order. I have considered the submissions made by the learned counsel for both the sides. This court is of the opinion that the learned trial court did not exercise a judicial mind while rejecting the prayer of the petitioner. Then, my lord, the prayer for
further cross-examination in this case was allowed, my lord. And my lord, Honorable Supreme Court, my lord, in a decision, my lord, that I have given, my lord, AIR 2013, Supreme Court 3081, my lord, after analyzing all the different judgments under section 311, my lord, Lordship may lay down the certain guidelines. Lordship may kindly come to, my lord, page 10 of that judgment, my lord. My lord, I'm a J, my lord. I'm relying on J and K, my lord. Page 10, my lord. J, may I read, my lord? Exigency of the situation, fair play and good sense should be the safeguard. While exercising the discretion, the court should bear in mind that no party in a trial can be foreclosed from correcting errors, and that if proper evidence was not reduced or relevant material was not brought on record due to any inadvertence, the court should be magnanimous in permitting such mistakes to be rectified. Then, the court should be conscious of the position that after all, the trial is basically for the prisoners, and the court should afford an opportunity to them in the fairest manner possible. In that parity of reasoning, it would be safe to err in favor of the accused getting an opportunity rather than protecting the prosecution against possible prejudice at the cost of the accused. The court should bear in mind that improper or capricious exercise of such a discretionary power may lead to undesirable results. So my submission is that, my lord, no prejudice should be caused to the other side, my lord. I want to put some questions, my lord. That prayer may be allowed, my lord, because this is a serious offense, my lord. And so this petition may be allowed now.
Okay, so Lordship. So I'm appearing as an amicus for the respondent number 2. No matter my learned friend has cited the judgment on 311, my lord, there is no dispute on the law, my lord. 311 can be exercised when it is essential for a just decision of a case, my lord. There is no quarrel on that point. Now the question is whether, my lord, in the facts of this case, 311 was the court ought to have exercised 311 or not. Because the petition, if you lordship have seen the petition had two parts. One was regarding de novo trial, another was regarding 311. Now he's not pressing on the de novo trial here, but there it was de novo trial was also pressed. Along with the 311 was also pressed. Question of if a person is in custody, judicial custody, and he is produced through VC, my lord, that is perfectly permissible within the scheme of the CRPC. 167 CRPC itself recognizes that through audio visual communication a person can be remanded. But 309 remand is a follow-up of 167. So that is permissible. Even our Guwahati High Court, now the VC rules are there, that also permit the production through VC. So when something is legally permissible, it cannot be said that that has caused prejudice, my lord. Secondly, to say that a legal aid counsel was defending the accused, if, my lord, that is taken as a ground, not every case where there are legal aid counsels, that will again lead to some anomalous situation. That if a legal aid counsel is there, that would somehow reflect badly on the legal aid counsel. So that is again, my lord, a problematic point. Now, as far as, my lord, not causing prejudice to the accused, that is also a valid point. But in the petition, my lord, the lordship knows that when an accused or the prosecution seeks to recall a witness for re-examination, they have to set out the questions, the grounds on which they intend to cross-examine the witness. Which were those points? Which were those questions which were left out? As the judgment of the Honorable Supreme Court says that nobody can be foreclosed from correcting errors. But then they have to show that these are the questions which I intended to ask the witness, but those were not asked. So because of, on that count, prejudice was caused. Without those questions being submitted, my lord, it is difficult to say actually whether prejudice was caused or not. So on that ground, my lord, I suppose this is not a case where 311 can be exercised based on their application. Had they filed a proper application giving all of these questions, then perhaps your lordship could have considered that aspect. Without those questions being given, my lord, it may not be a fit case for allowing a 311 application.
Lordship, here 311 may be used, but one thing is need to be taken consideration, Lordship, that it cannot be used to fill the lacuna of the case, Lordship. Moreover, delay part also need to be considered, Lordship, if they space for de novo trial, Lordship. So in their petition, they have not specified any grounds how they have prejudiced, Lordship. How they have prejudiced, because they have been given chance examination in chief is also there. And after that, cross-examination has been done by the legal aid counsel, Lordship. So it is proper in law, Lordship. So there is no defect in this illegality in this dear Lordship.
My lord, one thing, my lord, although in my petition in detail not stated about what are the questions should be asked, my lord, but I have annexed the evidences, my lord. I have already says, my lord, I'm just repeating, my lord, the contradictions of the evidence and the 161 is not put before the investigating officer, my lord. The victim was not examined about her age and in what class she was reading. And my lord, there are other aspects which are not brought. All the petition in all the details are not there, my lord. But if lordship goes through the evidence, my lord, then it is clear that, my lord, many relevant questions were not put. And my lord, the main thing is that what prejudice it will be caused to the prosecution, my lord. Because, my lord, if a innocent person is convicted, my lord, then it will cause, my lord, prejudice to the accused, my lord. No prejudice is going to be caused to the prosecution side or the victim or anybody, my lord. I'm only seeking one opportunity to cross-examine. My lord, even I do not want, my lord, 4 because he has not said much, my lord. Only witness number 1, 2, 3, and 4. PW 1, 2, 3, and 5, my lord. Only these 4 witnesses, my lord. 4 I do not want, my lord, because she has not seen anything, my lord. This only PW 1, 2, 3, and 5, my lord. These only 4 witnesses, my lord. Only one opportunity, my lord. One day they come and they will be cross-examined. Because if a person is convicted, my lord, 78 years, my lord, on a false accusation, then, my lord, it will suffer, my lord.
Thank you, President. Mr. A.K. Gupta, the learned counsel for the petitioner. Also heard Mr. K.K. Das, the learned additional PP, appearing on behalf of state respondent number 1. And Mr. S. Nawaz, the learned amicus curiae, appearing on behalf of the respondent number 2. Akili Hibo, this is an application on section so and so in connection with so and so. It is an application under section 528 BNSS, read with section 442 of the state code against the challenging the against the order dated 10/12/2024 passed by learned additional session judge cum special judge bracket or POXO Tinsukia in POXO case number 48/2024, whereby the petition number 1460/2024 was filed under section 311 CRPC, read with section 138 of the Indian Evidence Act, was rejected. It is submitted by Mr. Gupta, the counsel for the petitioner, that the present accused petitioner was sent to jail on 10/4/2024. Forwarded on 10/4/2024, and on the same day he was sent to jail Hajut. And subsequent dates also he was never physically produced before the learned special judge. The charges were also framed against him without his physical presence. However, he was produced through BC, and the charge was accordingly framed, read over, and explained to him. All the witnesses were recorded. All the evidence of all the witnesses were recorded. He was during that period also he was through VC only.
Yes, my lord. Even 313 examination I have annexed, my lord. It is recorded through VC and it was countersigned by the jailer on the next day, my
Already recorded, and in all these occasions he was he was never produced before the court physically, and the evidences of witnesses were also recorded. Uh, no, no, and during the period of evidence also he was produced through VC. Further, Mr. Gupta submitted that while according the statement of the accused petitioner under section 313 CRPC, he was not produced before the learned special judge, and through VC only the questionnaires were put to him, and the jailer put his signature on the next date his signature was also there.
Signature, but on the next day, my lord, page 25 is the 313 statement. Next day, on 29th, 313 statement was recorded. Page 25, my lord. This is 313, my lord. It was recorded on 29th day of October 2024. In the corner part, lordship may kindly see the, my lord, it was the signature of the accused is there. Then, my lord, countersigned by the jailer on 3010, my lord.
Which case is it? 313. And on the next day, that is on on the next day, the jailer put the counter signature of the jailer was put on next day, that is on 30/10/2024, wherein the petitioner was also put his signature. Further, he submitted that 3 legal aid counsels were there.
Different points of time, 3 persons were.
Further, he submitted that during the entire trial proceeding, 3 legal aid counsels were engaged for 3 legal aid counsels were engaged, and inadvertently, and 3 legal aid counsels were engaged, and as the petitioner is not acquainted with any other languages except Nepali, he was not but legal aid counsel they made the accused in the jail. Huh?
They never met, man. That is just, I have stated in my petition, man. They never met this person. Man. On page 35, the statement is there in my petition. That earlier consuls never visited jail to take instruction.
It's the last line to Kirilo. And the engaged legal aid counsel never visited to jail to meet him or to get the instructions from him. From the cross examinations of the vital witnesses, it is also seen that some of the important questionnaires were not put to the witnesses at the time of the cross examination by the engaged counsel. Inadvertently, which may be also inadvertently inadvertently, those the important questions were also not put to the so and so. On 3/12 next para, on 3/12/2024 only, when the relatives of the accused handed over the brief to the present advocate, he visited to Tinsukia jail And then only he came to know that the earlier counsels never visited to jail to meet him or to take instructions from him while cross-examining the PWs, Full stop. He further submitted that during the interaction, it also found that some true descriptions of the PO is not brought on record. And it was also not brought on record that there was a village meeting on the said concocted allegations, which was held on 9/5/2024. 24. More so, the age of the girl was not. More so, the age of the victim, the place of occurrence, etc., were also not put to the witnesses while cross-examining them by the earliest engaged counsel. Full stop. As the accused all along remained in the jail hazard and he was never produced physically before the learned special judge, the engaged counsel also did not get an opportunity to interact with the accused petitioner, who is only acquainted with the Nepali language. Nepali language. Full stop. Next para, Mr. Gupta further submitted that the allegations brought in the case is very serious in nature and punishment thereof is also severe, and as such, for fair and just trial of the case, the opportunity may be given to the accused. However, he submitted that at presently he is not insisting for any de novo trial, but the vital witnesses of the prosecution, that is EPW 1, 2, 3, and 5, are needed to be cross-examined, needed for further cross-examine to bring the actual truth of the case. Next para, he further submitted that he filed the petition before the accused petitioner filed a petition before the learned special judge, but by order dated 10/12/2024, that has been rejected with an observation that the accused was duly represented by his defense and his defense counsel, and he was on each and every date he was produced through VC. And considering these circumstances of this case, the petition for a petition filed under section 311 CRPC was rejected by the learned special judge so and so. Next para, Mr. Gupta further submitted that the court has the power to summon or recall or re-examine any witnesses at any stage of the case if it is required for the just decision of the case and also for the ends of justice. Further, he submitted that if the prayer for petition is not allowed to further cross-examine the vital witnesses, that is PW1, PW2, PW3, and PW5, there will be prejudice will be caused to the present petitioner. However, no prejudice will be caused to the state oblique respondents if the petitioner is allowed with one chance to cross-examine the PWs. In this context, he also home cost will given now. That is
Jail, my lord, 78 years person, my lord.
He is behind. In this context, he also relied on a decision of Honorable Supreme Court reported in year 2013, Supreme Court 3081, and basically relied on some guidelines provided in the state judgment.
Page 10, my lord. There are several guidelines, my lord, at page 10.
Following দুটা আছে, এটা J, এটা K. Page number 10. Page number 10, J or K to D. Next para. Mr. Das the learned additional PP submitted in this regard that all the PWs were duly cross-examined by the Defense Counsel, Learned Defense Counsel, and the present petition has been filed only to fill up the lacunas which cannot be allowed under the garb of the petition under section 311 CRPC. Further, it is further submitted that there is no grounds are being brought as to how the prejudice will be caused to the petitioner if petitioner accordingly he raised objection and submitted that at this stage the petition filed under section 311 CRPC cannot be considered, and the learned special judge had rightly passed the order rejecting the prayer for re-examination of the PWs, re-cross-examination of the PWs. Full stop. Next para. Mr. Nawaz, the learned amicus curiae, appearing on behalf of the respondent number 2, also submitted that the accused can be produced through VC and there is no legal bar to that. And during the entire trial, it is also seen that the legal aid counsels were duly represented the accused petitioner, and the PWs were also duly cross-examined by the engaged legal aid counsel. Further, he submitted that the 311 CRPC 311 petition can be entertained or can be entertained and be allowed at any stage of the case, but there has to be some specific. But if it is required for the just decision of this case and for the just decision of this case. But here in the instant case, it is also seen that there is no specification of any questionnaires which are to be put to the PWs, which were left to be put to the PWs and which may cause prejudice to the present petitioner. Accordingly, he also raised objection and submitted that the allowing the present petition at this stage will delay the disposal of this case, which relates to the section 6 of the POCSO. Hearing the submission made by the learning counsel for both sides, I'll listen to it. Okay, I'll have some decision. I'll put those citations and all. So your petition is allowed. We'll give a pass the list later part order. হেৰি যে আছে শব্দম আছে ন শব্দমক আপুনি ইয়াৰ পৰা যোৱাৰ পিছত ক'ব এটাতে 311 নাও পৰা 16 কিছুমান অৰ্ডাৰ আছে এই দুটা বা তিনিটা অৰ্ডাৰ উলিয়াই দিব দিছে কিছুমান কথা সোমোৱাই দিম কালিৰ কিবা এটা আছিল আমাৰ নাই However, abiding my.
Lordship,
Yes.
in this matter, I am praying for adjournment since we are being leading by Senior Counsel Z. Kamar due to his personal difficulties, Lordship. Lordship may fix the matter on next Friday or any other day convenient to your Lordship.
I'll make a little bit of submission. I'm not objecting to, but I'll just make a little submission, Your Lordship. On the last two dates by this Honorable Court, there was directions to pay the maintenance.
Maintenance.
Yes, but interimly, that was a direction was there and maintenance has to be, that was not being paid, Your Lordship. Now they are taking adjournment. That is the only point I'm just pointing out. Your Lordship will see two orders of this Honorable Court. First was this. There are two orders passed, Your Lordship. First is the order dated 10/1/2025. Lordship will kindly see 10/1/25. This is by Justice Midul Kolita. Here, Your Lordship will find in third paragraph, she submits the passing of the order dated so and so, an arrear of 1,35,000 has been accumulated. Considering the submissions made by the learned counsel for the party, the prayer for adjournment is allowed today. However, the same shall be subject to condition that on that day fixed, the petitioner shall deposit the arrear accumulated amount after passing the order dated so and so by this court to the respondent. The learned counsel submits this, he may be allowed to give exact quantum of arrear accumulated on the next date fixed. Now, what has happened, Your Lordship? This was not paid. On the next day, they came up by saying that they have paid an amount of rupees 80,605. And that day, I could not, Your Lordship, submit that it was not, that was not paid on that period because I did not have the record. Today, I have got the record. I have seen this amount was paid much prior. That was with regard to some earlier, Your Lordship. That was given on 23/20/24, much prior to this order, Your Lordship. After this order, there was a specific direction, pay 137 till a final decision with regard to
No,
the.
80,000 was paid on when?
It was paid on 20/03/2024. And they have submitted that they have paid it. That is why, Your Lordship, I am pointing it out, that this amount was also not paid. This was an earlier amount. The chart, the court has said that you finally decide what is the total amount. Till then, you paid 1,37,000. That was the direction of this Honorable Court. On the next day, they came up, said that I have paid already 80,000 have been paid. That was recorded by this court. I did not object because at that point of time, I was not sure whether that was paid or not. Then I took out this, Your Lordship will kindly see the record. That record, the SBI account. This amount at the second page, Your Lordship will see there's a tick mark. This is by Bhoban Kumar. On 20/03/2024, this 80,605 has been paid. So they made a wrong disclosure before this Honorable Court on the last date saying that they have paid it. That was not paid. That was an earlier amount which was paid. This was direction was on 10/1/25. Subsequent, they have to pay 137. And after that, there should be a calculation made, and then the rest amount can be decided. That was a direction. They have not done. Now, what has happened, Your Lordship? That was with regard to the educational fees of the petitioner's child. There's one more direction was there by this Honorable Court to pay 6,500 per month. There was a direction by the family court that you pay 13,000. There was a stay order passed by this Honorable Court directing that you pay 50,000. This 6,500 have also not been paid from October 2024 till date. That has also been recorded by this Honorable Court. Now, today they have not paid. This is under that circumstance. I am not going to object for any, Your Lordship, adjournment because senior is not there. But question is that they should be very fair to the court saying that we have not paid, we paid within so and so day. They're not doing that here. This is what is going on. So that is why I'm making this submission. Otherwise, I wouldn't have said all these things. And on record, Your Lordship, it is seen that this 80,605 is paid in March 2024, not in February or March this year. So that is absolutely a wrong submission made. Once you pay an amount of 80,000 and all throughout you will say that 80,000 is paid, 80,000, court also was saying that yes, already something has been paid, rest will be paid. That was a view taken by the court. But that is not true, Your Lordship. Not a single penny has been paid till date. That the adjournment may be given, Your Lordship, subject to the condition on the prior to the next day, this amount may be paid. At least direction of 10/1/2025.
to be complied with, as well as the area amount from October till date, that is about 39,000, that should be paid, these two amounts.
Lordship, I vehemently oppose the prayer which my learned senior has prayed, Lordship. Lordship, if Lordship peruse the order dated 25/8/23, we have approached this honorable court against the order passed by the family court, learned family court, against miss case number 128/21, where the learned family court had stated the claim of the raise the maintenance amount up till means up to 13,000. Against that order, we have approached this honorable court regarding the other part, Lordship, that execution proceeding is already going on. In that case, they have already stated all these facts, and that matter is sub judice before the learned family court, Lordship. The matter is still pending. There also they are claiming the same fact. Here also they have come with the same fact, Lordship.
No. There, obviously, there's a execution is pending.
Yes,
It is
Lordship.
understood, but the question is that Mr. Mannan, what is saying, he is saying that here in the case record, if you go by the case record, there was 3 orders were there.
Yes, Lordship.
On 10/1/2025, it was an observation that 1,35,000 has been accumulated as per order from the order dated 25/8/2023. So that was the direction that it has to be paid. On the next date, again, we have made an observation that you have submitted that 50% of the said amount has already been paid.
Yes,
That is the 80,000.
Yes.
Now,
Regard-
Mr. Mannan is saying that 80,000 which was been paid, it was paid on 20/03/2024, in fact, not in between this area.
Regarding
is
that
the issue.
80,000 which my learned senior had referred, that case is already been pending in the learned family court, Lordship, and the next date of that case is 5/4/25. It's still sub judice regarding the payment part, Lordship. Here we have approached against the order of against the miss case order of 128/21, where the family court has raised the maintenance from 13,000 to 6,000, means from till 13,000. Has raised the maintenance amount to 13,000. Against that order, we have approached this honorable court. And regarding the non-payment of the claim, means maintenance amount, which means the monthly maintenance, which my learned senior had referred, this is the certified copy, Lordship. It will reflect everything, Lordship.
You are paying?
Yes, everything is there, Lordship. Lordship may kindly refer, Lordship. Yesterday also they had deposited, the day before yesterday, Lordship.
132,000.
Yes, one amount was area that it was an inadvertent mistake of the petitioner, which had been left out, and that has been paid the day before yesterday. It's reflected in the order copy, Lordship.
কোনটো amount দিছে বুলি ক'লা? কেতিয়া দিছে? পৰহি দিছে।
Next 5 তাৰিখে কেছ আছে, 5 তাৰিখে এটা মূল্য কৰিব।
সেইটো মই গম নাপাওঁ, মোক কোৱা নাই। যদি দিছে তেতিয়াহ'লে ঠিক আছে। But I have not received it. মোক ক'লে মই গম পালো। মই গম পোৱা নাই। যদি দিছে এই পাৰ্টটো ঠিক আছে, fine. কিন্তু এই 80,000 টো কিন্তু আগৰ হয়। But that has been reflected in the order. Then why you have submitted? সেইটোৱে কথা। My question were in this case, Your Lordship, he has said that is 80,000 with regard to some other people. But question is that they have submitted in this court, before this honorable court in the earlier, that they have paid this amount. They shouldn't have submitted 1,37,000. We are not going to pay. They should have said. Why they have said we have paid 80,605. That is why I am saying this amount of 137, the court has reflected that it is on the basis of 25/8/2023.
It is also
This area, if there is a direction of the court, they should have filed a review petition before the court saying that no, this order is wrong. You pass a different order. Court's order is there. Now they cannot come up and say, no, we have, and they did not say this order is wrong. They came up say we paid 80,605, and that was recorded by the court. That day also they did not say it is not with regard to some other amount. Now today again he's coming and saying, no, that is with regard to the other case. Now what my learned friend has said.
What he has submitted, I can understand that one execution case is pending.
That is pending, yes.
Wherein those matters are the area amount, these
Area amount is
accumulation,
there.
these are the questions.
Yeah.
But now what he is saying, Mr. Mannan is saying that the question is that you have admitted before this court that 80,000 has been paid.
Lordship.
After the 10/1/2005, that's what you are saying.
Yes.
Otherwise, okay, then let it.
Then
be fixed
one
on-
more thing, Your Lordship, with regard to what he has said, that
they have paid that 39,000 or so.
Yes.
That has been
On
paid,
record.
that I do not have the instruction as of now. If that is paid, then it is okay. I'm not going to say. that.
Because after depositing that amount, Lordship,
It
the
was deposited,
respondent,
he said on
respondent may
yesterday,
be
no?
informed over phone by the petitioners council that we have deposited so and so amount through check, kindly take that check.
Where is
Withdraw
the
the
check?
That is reflected in the order.
Yeah, order to do. If that is there, I will not argue on that, obviously. But my question was that basically there was a direction of this court. You pay the amount. If that is not required, then the amount can be required. 32,000 delay.
My check number, so.
So.
It will balance.
बाकी कितनी चाहिए? 39,000 1,500 होगा।
6,500 March into
500 तो दिया ना।
March लेके दिया सर. April or into
32 होगा। Anyway, this over.
You are Mr.
RM Das.
RM Das, appearing on behalf of Mr. Richard Kamar. Your name is here only, RM Das. Your name is here only.
Yes, Lord.
Yes.
RM Das, the counsel for the.
There are actually two matters, Your Lordship. That is why the
So
one
you
case.
are, basically, you are for the petitioner, in fact.
No, he is for the
I am for
petitioner in the first case. Second case, I am the petitioner. In the second case, all these, Your Lordship, issues are taken up by the petitioner in the second case. The second case actually is on the basis of the order passed by the court fixing the amount to 13,000. In fact, enhancing the amount to 13,000, which we have filed, asking for a further enhancement to 25,000.
So, this is an RM Das, opinion also, and it is submitted by him that the senior NBS counsel, Mr. Jed Kamar, is not available today and accordingly sought for an adjournment. So, Mr. Mandan raised no objection in adjourning the matter. However, he submitted that. And on 10/1/2025, there was a submission that the area amount is accumulated to rupees 1,35,000 and 1,35,000 and
Then,
and was allocation for payment of the area accumulated amount, area to payment for the area amount. But on 23/01/2025, it is submitted before by the respondent that they have already filed 50% of the area amount, that is 80,605 to the petitioner. But but from the statement of the SBI, it is seen that said amount of 80,806,605 was paid only on 20/03/2024, which is much prior to the order passed by this court or for the accumulation of such area posters. In this context, Mr. Das submitted that those area amount, etc., are still under is still under pending before the executing court. And in the meantime, the petitioner is also regularly paying and respondent is also regularly paying the monthly maintenance at the rate of rupees 6,500. Considering the. So now, do you need any direction? Because if they are paying.
No, they have paid because of this order of this honorable court. Now they are paying because the matters come up. They paid yesterday. No, day before yesterday. No?
On
Yes.
19/3/25.
Yes, anyway.
19/3/25, we have.
They have paid this amount.
19.
And that was, this amount is 6,500 into something, I think 4-5 months together they are paying. So earlier they did not pay. I came up and said, then they have paid now this amount. Anyway, there is
was
one.
an inadvertent mistake, Lordship, of the petitioner side.
There may be so
I do
many.
admit. I do admit.
Okay, then we'll be listing the matter on
After Bihu,
after Bihu.
Lordship.
At least one observation, Lordship, they may continue paying with the.
Yes,
that
we
debt.
But also if the matter of area maintenance is pending before the executing court, there may not be any further order for payment of the area maintenance. However, the petitioner is hereby directed to pay the regular monthly maintenance at the rate of 6,500.
Now it is as per the interim order.
To the petitioner as per the interim order. List accordingly after Bihu vacation.
Lordship. Interim may continue, Lordship.
Interim was there. Review vacation, interim will continue till next date of posting. It will be listed after review vacation.
Lordship.
Lordship may fix 23rd, 24th like that. Better on maintenance matter.
Will be on 2/5.
2/5.
2/5.
Lordship. If interim may continue. Lordship.
Interim will be continued.
Lordship.
I'll go to material code.
Final. Lordship, my lord, that last order, my lord, that government advocate was implemented as a party response number 2, lords. And why this response number 2 has been implemented, I do not know. And lordship may kindly goes to the annexer 1, page 14. This is the doubtful documents, lords.
Page 14.
I think it is
Page
14, lordships.
Huh?
14, 1
14.
This is the documents, lordship, 1955. And on that time, lordship, the Dibrugarh district was also not there. How, my lord, the first class magistrate, lordship, Margarita, my lord, is there. And in the inquiry, lordship, my lord, kindly goes to the page number 17, lordships.
Page number?
17, 17. And 1, 2, 3, 4, 5, 6, 7. My lord, last 7 from the bottom, lordship. However, lordship, good. However, an inquiry, it is found that the Margarita Court as well as the subdivisional officer, civil, Margarita was established during 1980. Lord. During that time, my lord, that all this, my lord, that portion was, my lord, under the Lakhimpur district, lords. Dibrugarh district was formed, my lord, in the year 1972, lords.
So this is the FIR or what? FIR.
This is the FIR, lords. On the basis of that FIR, my lord, that some investigation has been made and the searches has been submitted and the trial is going on.
That document was
Well, that
seized in connection.
it was lordship. Well, they have submitted that 1955. On that time, the first class magistrate, that is not there. How can these documents, my lord, they are produced? That is only doubtful documents. That's why, my lord, this affair has been lost.
This that was shown to be issued on 1980, 1955.
55. 1980, my lord, that subdivision, my lord, Margarita, my lord, that subdivision was formed. In 1955, my lord, that this is all our, my lord, under the Lakhimpur district, lords.
So you are for quashing.
For quashing, my lord.
For quashing of charges, my lord, I would like to highlight the fact, my lord, which will be beneficial to all of us. My lord, by Annexure 1 is a affidavit sold by the petitioner number 1 and 2 father in the year of 1955. Stating the fact that he was a citizen of within East Pakistan. Now it is Bangladesh. Now, he has migrated from the East Pakistan in the year of 1953, my lord. And he has started settling in the Tinsukia district of Assam, my lord. Now in Margarita, his generation is residing in Margarita. Now what had happened? During the period of NRC, my lord.
So here we have received the scan copy or what is the stage of the case in fact?
Scan copy received, as in the causes it is shown, lords.
Have you gone through the scan copy?
My lord, we're not able to go through the scan copy, only my lord that part.
Anyway, I just asked where the scan copy is. What is the stage of the case at present?
As my lord, the consideration of charge. I have annexed the other orders for consideration of charge. The next date is, my lord, next date is 25/4/2025. So what happened, my lord? This affidavit was shown stating that he want to be a citizen of India, as he is a refugee. So he want to be a citizen of India, and along with him, his wife, his children, and his brother, he want to be citizen, as far the affidavit is concerned. This petitioner, the present petitioners, who in the year of 2019, my lord, while NRC process was going on, at that time, this affidavit was produced before the circle officer comes CRCS at Margarita, my lord, and on the ground that they're unable to produce any linkage with them. There is no linkage, so they have produced this affidavit with a view to
Which one? Which one? Affidavit?
this affidavit, annexure 1, page 14, my lord. Page 14. As the forefathers made an affidavit before the authority that he wants to be a citizen of India, as he is a refugee and he has migrated from Bangladesh. And nothing is there. There is no fabrication. There is nothing else. Thereafter, my lord, what happened? CRCS circle officer made has a doubt in mind. Circle officer has made an inquiry, and as per the inquiry report, it was found that the Margarita Code was established in 1980, my lord, and subdivisional code was established in 1998, my lord. Now, what has happened? They have found that there was no Margarita Code. That is why the FIR was lodged, my lord. FIR was lodged, page 17. But in the FIR, my lord, this affidavit was not shown by the present petitioners. There are 6 petitioners. They were not shown by the petitioners. In the affidavit, their forefathers shown the affidavit, stating that he wants to be citizen of India. And their name is entered in 1966, 56, and everything in the voter list. And they are a citizen of India, my lord. Now, casting doubt upon the affidavit, this FIR was lodged by the circle officer before the Margarita police station. Accordingly, the Margarita police registered the case and submitted the charge sheet, my lord. My lord, if your lordship kindly have a look of the charge sheet, my lord, page 26. My lord, there is no prima facie materials against the present petitioners. Which, my lord, kindly have a look. Page 26, operative part is page 27, my lord. Charge. Page 27, my lord. Translated into English, my lord. And my lord, during the investigation of the case, so-and-so was recorded as well as the name mentioned FIR respectively. So-and-so, 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 so anticipated bail through the honorable court and appeared before the court and interrogated them. 41 and notice CRPC was issued against them. During the further investigation, the other accused, namely so-and-so, so-and-so, notice was also issued against them. During further investigation, it was known that Philani Devnath mentioned in the FIR had already died, but the family members could not produce any death certificate during the further investigation. Subsequent lines below, my lord, the name mentioned in these are respectively so-and-so, 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 my lord. Last part, my lord, page 28, my lord. Kirat Gate, Lekhabani district, Assam are charged under 467, 471, 34 IPC. All of them, 6 persons are there. Their residence is mentioned there, and they were charged under section 467, 471 by the police, as per the charge sheet is concerned. But as per the my lord, ingredients of section 467, 471, my lord, they did not commit any offense, my lord. This affidavit is not shown by them. It is the affidavit shown by their forefathers. And on they find out in their house, and accordingly, on good faith, they have produced before the NRC authority along with other documents, my lord. So that is no prima facie case made out against the petitioners, my lord, as far as the charge sheet is concerned. Apart from this, my lord, the petitioners have filed this present petition. At the same time, the learned court below, my lord, given the date, so so many dates I have annexed, my lord, but charge is not yet framed, my lord, due to one difficulty or the other. So since the criminal petition is filed before this honorable court, my lord, at least at this stage, the further proceeding before the learned trial court be stayed and let it be decided, my lord.
What state? You finally, we are hearing the petition.
My criminal petition, my lord, I have filed.
What?
Criminal petition, my lord.
So this is the criminal petition. We are hearing on this petition. Then
Yes.
what is the interim prayer you are asking for?
My lord, my prayer is before your lordship, my lord. Since the petitioners are cooperating with the honorable court, appearing before the honorable court in every date, my lord. So many dates already left, my lord. And the next date is 25/4/2025, my lord. So the next date also case is fixed for consideration of charge. In the meantime, my lord, let this matter be finally disposed of, and the
Your final disposal only, we are
Yes.
hearing. This is matter for final disposal. You are here, you're submitting. We are hearing.
this is my son. Finally disposed, my lord, and pass necessary order, my lord.
This is in admission column, in admission stage itself, we are arguing the matter. So we are hearing, and what kind of interim, I don't know. It will be for final only.
Yes.
The matter will be finally disposed of. That's what I'm saying.
My lord, kindly, I finally dispose this.
It's obviously, that's
Yes.
why we are hearing only.
So there is, as per the ingredients of say 467, 441, 71, my lord, there is nothing, my lord. They have not committed the offense. They did not done anything against their will or against the will of the authority, my lord. They have thus submitted this document. It is admitted fact there was no court, my lord, but their judicial court is there, no doubt, my lord. The magistrate first class was, judicial magistrate first class was not there at that period of time in Margarita, my lord, but magistrate first class was there. So I do not know regarding that fact, my lord. So there is no intention on the part of the petitioners to commit fraud or anything else under 467, my lord.
Lordship, after going to the scan copy of the case, Lordship, it has been seen that, Lordship, in the charge sheet, it is stated that, Lordship, the Margarita was found in 1980. It was established, Lordship. And this document, which he has submitted, Lordship, it is a first one. However, one thing is that I want to stress on that, Lordship. One letter from to the circle officer regarding the authenticity of the document attached in so and so, Lordship, dated so and so. We have not received any, whether it has been authenticated or not. Whether it is genuine or not, that I have not found. In the scan copy, Lordship, one to the sub-judicial district magistrate, one sent to this circle officer, Lordship, regarding the authenticity of the document, Lordship, that they have submitted in 1955. I have not found that, but in the charge sheet, it is stated that Margarita যোৱা 1980 চনত স্থাপিত হৈছিল, গতিকে নথিখন জাল হিচাপে প্ৰমাণ পোৱা যায়. It is stated in the charge sheet, Lordship.
It is not yet established through any piece of evidence.
Moreover, prima facie case has been established, Lordship. And charge sheet has been submitted. And if he has any document, and he may be discharged then, Lordship, in the trial court. But now, at this stage, prima facie case has been established. So it cannot be quashed.
Then only, that's 1971, Dibrugarh district was formed. So the first class magistrate regarding that Margarita, how can he issue this that affidavit? When before the first class magistrate?
My lord, the bone of contention, if I am not mistaken to highlight the fact, my lord, bone of contention is that magistrate first class and judicial magistrate first class. This is the bone of contention. This affidavit was sold, annexure 1, my lord, it is before the magistrate first class, not the judicial magistrate first class.
Obviously, it is magistrate first class.
Yes.
But if you
And
go by just a second, if you go by the FIR.
Yes.
FIR itself, it is saying that it's not clarifying that it is the judicial magistrate first class, but it is magistrate first class.
Yes, that was.
No. FIR, as per FIR also, it is the observation, as per from the report of the so-and-so and after inquiry, it has come to knowledge.
Yes.
The no magistrate first class was there in 1955 with Margarita. Not we are talking about the judicial magistrate. Judicial magistrate, we also know judicial
Yes.
magistrate first
No,
class
no,
was
it must, yes.
subsequent.
Yes.
But they are talking about the magistrate first class, not
Yes.
judicial magistrate.
SDO civil was established in 1980.
SDO civil.
My lord, Deputy Commissioner, ESC and ST civil are magistrate first class also, my lord. Judicial Deputy Commissioner, ESC and my lord, SDU civil are magistrate first class, my lord.
That's what he is saying, that
Yes.
SDO civil is only also established in
1980.
Court of SDO civil is also established in 1980.
55, how can 55 come?
So there was no existence of any SDO, rather SDO was also.
There
not
was
there.
no existence by that point of time. Judicial court was not established, but
How your affidavit was executed or sworn? That
Ma-
is the question.
my lord, this
Because
is
those forced documents where you, on the basis of those forced documents, you applied before NRC.
Yes, NRC, yes.
That is the case. When NRC was, it was, then only it has come to knowledge that this is a completely a forced document on the basis of which you are claiming as an Indian citizen, whatever, before the NRC court.
my lord,
That is the case.
my lord, this affidavit was sold by the forefather. They were.
But you are now taking that advantage of that affidavit.
Yes.
Then, if you have any other documents, you could have produced before the NRC office. It's not bad. Yes, your forefather may come in 1955. They may have they may be the citizen of India. There is not disputed. But the question is that on the basis of the forced document, you applied for the NRC. That is the main crux of the case. Obviously, you were not there. Your forefathers were there.
Yes.
If you have any other document to prove yourself as an Indian citizen, why don't you bring all these other documents? You can appear.
They are citizen, no doubt, my lord. As of now, they are
Yes,
citizen.
they are citizen.
Yes.
They may be
Yes.
citizen. We are not in that.
Citizen, there is no doubt. Mala, the documents, those
Yes.
who have, Mala.
The only
that have to
documents.
be
You are maybe a
submitted
citizen of
at the
India.
time
now.
of Mala, apply in the NRC.
Yes.
You may be a citizen. That is not doubt. We are not doubt. Because in 1955 only if your forefathers came, then obviously you may be a citizen.
As a Hindu refugee, my lord.
Whatever.
And there are some statutes are there, my lord. They have given citizenship.
Huh?
Other state, my lord, previously, some statutes are there. They have given citizenship, which I am not going to discuss.
Yes, some refugees were
Yes,
there.
yes.
They came, they took shelter. The refugees were already there. Kim.
Yes. Okay.
Right.
Right.
Lordship? Lordship can keep it as part. Subject to what they say, my lord, I have only 2 or 3 legal points. On my part, I will not take long time. The lordship can keep it part here also, my lord, subject.
Lordship, another. Lordship, the case of the petitioner is very simple and precise. The respondent number 2 is the second wife of the petitioner. Out of his first marriage, he had 4 sons. He is looking after his 4 children. He is looking after his 4 children. 4 children, yes, Lordship. Lordship, the respondent number 1 had filed for maintenance under the Domestic Violence Act. Second wife, Lordship, respondent number 1. Lordship, as per order dated 21/12/23 of this honorable court, this honorable court was pleased to stay both the matter of criminal appeal number 42/23 arising out of judgment and order dated 15/9 and by the learned judicial magistrate first class and in DV case number 609 of 18. Both the matter has been stayed because this honorable court has found merit. One is criminal appeal 42 of 23. And another is criminal appeal 42 of 23 and another is DV case number 609. Both the matter has been stayed because this honorable court has found merit in this case. My submission is only that, Lordship, during the time of her complaint petition, she has concealed the fact that she is already married to one person named Sirajuddin. She is already married to that person. For 14 years, they had been living as husband and wife. Because of domestic violence, she came from that person and she married this petitioner. She married the petitioner, Nurul Islam, but she has, yes, Your Lordship, this is her second marriage, but she has concealed the fact that she is already married to Mr. Sirajuddin. Respondent number 1 is, her first marriage was with Sirajuddin. Her second marriage is with Nurul Islam. Lordship, she has concealed the fact that she is already married to Sirajuddin from her present husband. So as and this has only been came into limelight at her PW1 clause. Lordship may kindly peruse page 29. Her statement was, before my marriage with Nur Islam, I was married to one Sirajuddin of Rangalu and I stayed there for 14 years. I was being tortured there and therefore I came from there as I was tortured for 14 years. Lordship may kindly look into here. I have not filed any application before any Qazi office in order to obtain talaq, nor have I filed any divorce suit. This clearly indicates that, Lordship, she has not taken divorce from her first marriage. So this marriage is totally void. Her marriage with Nur Islam is totally void, Lordship. And her previous marriage is still alive, Lordship. And her sister in the clause of PW2, Lordship kindly looks into page 33. Anwara Khatun is a sister who has also said the exact thing. That my sister was married to the son of Kazimuddin Master, that is Sirajuddin of Rangalu village. I do not know whether Sirajuddin is alive or not. Her sister has also confirmed that she is already married. And in her statement, she has clearly stated that she has not filed any application for divorce. Lordship, this indicates that she is already married to another person. Her marriage is still alive, so this marriage is void. Her subsequent marriage is void, and as per Mohammedan law or any other law, woman cannot marry another man during the subsistence of her earlier marriage. And moreover, Lordship, DV Act itself is not applicable in this case. Moreover, Lordship, DV Act is also not applicable in this case, and she is not entitled to any maintenance under DV Act. if her marriage is also void, she is not entitled to any maintenance. And moreover, Lordship, she has not, she is a working woman. Her means of livelihood is unknown to us. They may file an affidavit showing her means of livelihood. Yes, Your Lordship, she is a working woman.
Yes. So this is a case where they initially, the respondent number 1, madam. Yes, madam, I'll clarify the facts, madam. What has happened? I filed an application under section 12 of the DV Act, madam. That got registered as DV case number 609 of 2018. In that case, my lord, an order was passed that the petitioner will pay me 5,000 rupees per month as maintenance, and there was another order of 40,000 rupees of compensation, my lord. Now, against this order, they have preferred an appeal under section 29. That appeal is still pending, my lord. Now, your lordship will kindly come to page 27, my lord. So what has happened when they have preferred this appeal has been admitted. When the appeal has been admitted, condition was there that they will continue to pay 50% of the maintenance amount. Subject to that condition, the appeal was admitted. Now the appeal is still pending. Now, of course, they have managed to secure a stay because they are basically agreed with this direction to pay 50% of the maintenance amount. They have got a stay in the appeal as well as in the execution of the DV case. Otherwise, whatever contentions they had, they can very easily agitate these contentions before the appellate court. Now, when they are challenging this order, the DV Act final order is already under challenge in the appeal. So there is no question of that order again being challenged before this honorable court. The other order which is under assailment is the order whereby the appeal was admitted and this condition was stipulated that 50% would be paid. Now that order, my lord, is a purely interlocutory order. Now, if it is an interlocutory order, my lord, the bar under section 397(2) would be applicable. This is an revision application. It's not a criminal petition. It's not a 226 or 227 proceeding. It's an application under 397 with 401. So clearly, my lord, 397(2) bar is clearly applicable in this case. That is one aspect, my lord. Now, my lord, whatever be the merit of the case, that will be decided in the appeal. Appeal being a continuation of the main case, my lord. If they are agreed with the direction to pay that 50% of the maintenance amount, why get a stay in the appeal? Appeal could have been decided on merit. Why the entire appeal should get stayed, my lord? That proceeding is already open to them. And regarding this aspect, my lord, that I had already a husband. Again, my lord, that all those are matters of record. But this is not a case under section 125 of the CRPC. This is a case under the DV Act. Now, DV Act section 2F, my lord, of the Act is very clear as to what is a domestic. All I need to be is in a domestic relationship with the man. Domestic relationship includes a relationship by way of consanguinity, a relationship by way of marriage, and also a relationship in the nature of marriage. So if we have been living together, even if I had another husband earlier, with whom as of now I have absolutely no relation, and I also dispute that fact, whatever be it, my lord, that will not extinguish the nature of domestic relationship. So domestic relationship itself would remain. So a DV Act proceeding will anyway be maintainable. Apart from that matter, now this issue has already been clarified by the Supreme Court in a very recent judgment, matter. 2025 judgment. Exactly this issue, madam. Earlier also, your lordship would be aware those Chanmunia judgment was there, Dwarka Prasad Satpathy judgment was there. That even in 125 proceeding also, if it's the relationship in the nature of marriage, it would still be considered. But there it is very specifically discussed. My lord, will kindly come to para 10. What did you interpret that? Okay. Para 10. This is a 125 proceeding. Even in a 125 proceeding, this is para 10, my lord. We have heard the learned counsels for the parties and perused the record. The short question before us is whether a woman is entitled to claim maintenance under section 125 CRPC from her second husband while her first marriage is allegedly legally subsisting. So this is the precise issue which they have raised. So even if it has somehow accepted that she had a legally sustaining marriage, my lord, whether 125 proceeding would be there or not. At the risk of burdening the judgment, it is imperative to reiterate the objective of maintenance under section 125 CRPC as laid out by Justice Krishna Iyer in so and so case, while upholding the award of maintenance beyond the monetary limitation prescribed under the provision. The court held the provision is a measure of social justice and specially enacted to protect women and children and falls within the constitutional sweep of Article 15(3), reinforced by Article 39. We have no doubt that sections of statutes calling for construction by courts are not petrified print, but vibrant words with social functions to fulfill. The brooding presence of the constitutional empathy for the weaker sections like women and children must inform interpretation if it has to have social relevance. So viewed, it is possible to be selective in picking out the interpretation out of two alternatives which advance the cause and the causes of the derelicts. The purposive interpretation was pressed into service by three-judge bench in so-and-so case whereby maintenance was granted to the second wife as the respondent husband was unable to conclusively establish his first marriage. The court held Section 125 of the CRPC is meant to achieve a social purpose. The object is to prevent vagrancy and destitution. It provides a speedy remedy for the surplus supply of food, clothing, and shelter to the deserted wife. When an attempt is made by the husband to negative the claim of the neglected wife, depicting her as a kept mistress on the specious plea that he was already married, the court would insist on strict proof of the earlier marriage. The term wife in section 125 of the Code of Criminal Procedure includes a woman who has been divorced by a husband or who has obtained a divorce from her husband and has not married. The woman not having the legal status of a wife is thus brought within the inclusive definition of the term wife consistent with the objective. However, under the law, a second wife whose marriage is void on account of the survival of the first marriage is not a legally wedded wife and is therefore not entitled to maintenance under this provision. Therefore, the law which disentitles the second wife from receiving maintenance from her husband under section 125 for the sole reason that the marriage ceremony, though performed in the customary form, lacks legal sanctity, can be applied only when the husband satisfactorily proves the subsistence of a legally and valid marriage, particularly when the provision in the code is a measure of social justice intended to protect women and children. We are unable to find the respondent here. That is matter I'm skipping. Next part, para 13. Similarly, in this court in Dwarka Prasad Satpathy versus so-and-so, granted maintenance where proof of marriage was inconclusive. The court noted that the standard of proof of marriage while claiming maintenance is not as strict as it is required in a trial of the offense under 494. Now, the different view is also cited, my lord. Para 14, a different view was taken by this court in so-and-so, whereby maintenance was denied to a second wife during the subsistence of the husband's first marriage on a strict interpretation of the term wife under section 125. The court gave supremacy to the intention of the legislature, which specifically included divorced women within the purview of section 125 CRPC, but did not mention de facto wives whose marriages are void ab initio. This view found favor in so-and-so case, where maintenance was similarly denied on the plea of previously subsisting marriage. The case relied on by the respondent comes on the heels of those decisions. This divergence, now this is discussed here, this divergence in judicial opinion has been noted by the court in Chanmunia, and therefore the question of whether women in live-in relationships can claim maintenance under section 125 CRPC was referred to a larger bench. The discussion to the exact extent relevant is reproduced below. Thus, in those cases where a woman who lived with a man who lived with a woman for a long time, and even though they may not have undergone legal necessities of a valid marriage, should be made liable to pay woman maintenance if he deserts it. The woman should not be allowed to benefit from the legal loopholes by enjoying the advantage of a de facto marriage without undertaking the duties and obligations. Any other interpretation would lead the woman to vagrancy and destitution, which the provision of maintenance in section 125 is meant to prevent. Para 25 is on Malimat Committee, and para 42. We are of the opinion that a broad and expansive interpretation should be given to the term wife to include even those cases where a man and a woman have been living together as husband and wife for a reasonably long period of time, and strict proof of marriage should not be a precondition for maintenance under section 125 CRPC, so as to fulfill the true spirit and essence of the beneficial provision of maintenance under section 125. We also believe that such an interpretation would be a just application of the principles enshrined in the preamble to our constitution, namely social justice and upholding the dignity of the individual. Most recently, in Barsha versus Urmila Barsha Godse, this court granted maintenance to a second wife who was kept in dark about the husband's first subsisting marriage. The court noted, again, now para 17. This encapsulates the whole scope and gravity of the considerations before this court. As we deliberate on the issue and form, the present case does not concern a live-in relationship. Family court made a factual finding that appellant number 1 married the respondent, and that finding is not disputed by the respondent. Here also, my lord, the fact that petitioner and the respondent were married, that is not in dispute. What they are disputing is that I already had a subsisting marriage. Similar is the case here. Instead, the respondent seeks to defeat the right of maintenance by claiming that his marriage to appellant number 1 is void ab initio, as her first marriage is still subsisting. Exactly, my lord, facts of this case. Two other pertinent facts must be considered. Firstly, it is not the case of the respondent that the truth was concealed for him. Again, this is not a fact, though they have said it that it is concealed. This is not a fact supported by record. In fact, the family court made a specific finding that the respondent was fully aware of the first marriage of the appellant number 1. Therefore, respondent knowingly entered into marriage with appellant number 1 not once but twice. Secondly, appellant number 1 places before this court an MOU of separation with her first husband. While this is not a legal decree of divorce, it also emerges from this document and other evidence that the parties have dissolved their ties and they have been living separately. And appellant number 1 is not deriving maintenance from her first husband. Therefore, barring the absence of a legal decree, appellant number 1 is de facto separated from her first husband and is not deriving any rights and entitlements as a consequence of that. Now, my learned friend has read the evidence, my evidence cross-examination, my lord. Kindly come to page 29, my lord. This judgment also talks about a memorandum of understanding between the appellant and her first husband. Here also, my lord. First lines which my learned friend had read out, that I have not filed any application before any Qazi office in order to obtain talaq, nor have I filed any divorce suit. We had a compromise in the court through understanding. So the fact that this husband, this respondent was no longer in a marital relationship with her husband is also deposed by her in her cross-examination. The very cross-examination which was elicited by the petitioner side. Of course, that will not absolve her of proving that the earlier marriage had been dissolved. But in light of this judgment also similarly says that though there was absence of a legal decree, appellant number 1 is de facto separated from her husband and is not deriving any rights and entitlements as a consequence of that marriage. Again, this is not their case, that I am somehow taking any maintenance from the first husband. So in the opinion of this court, when the social justice objective of maintenance under section 125 CRPC is considered against the particular facts and circumstances of this case, we cannot in good conscience deny maintenance to appellant number 1. It is settled law that social welfare provisions must be subjected to an expansive and beneficial construction, and this understanding has been extended to maintenance since Ramesh Chandra. An alternate interpretation would not only explicitly defeat the purpose of the provision by permitting vagrancy and restitution, but would also give legal sanction to the actions of the respondent in knowingly entering into a marriage with the appellant number 1, availing its privileges, but escaping its consequent duties and obligations. Here is also a case where they live together. Now he is trying to escape his duties and obligations. The only conceivable mischief which could arise in permitting a beneficial interpretation is that the appellant number 1 could claim dual maintenance. However, this is not the case under the present facts. This is also not our case, my lord, that somehow we are claiming dual maintenance from our first husband. So, my lord, this is a case under 125 CRPC, when 125 CRPC otherwise says wife, legally wedded wife. Yet the Honorable Supreme Court, since the time of Chand Munia, has clearly said that this does not have to be a legally subsisting marriage, my lord. Even if they are in the nature of, is the relationship in the nature of a marriage, even then 125 is applicable. DV Act, my lord, this does not even recognize the concept of marriage. In DV Act, my lord, it is consanguinity. A brother can also claim from a sister, mother can also claim from a son. Likewise, if somebody is in a live-in relationship, somebody is in a relationship which is in the nature of a marriage, where they had otherwise relations, my lord, conjugal relations. In that case, DV case itself allows for claiming maintenance. So accordingly, we filed the case. We got an order, we got an award, 5,000 has been paid. They have preferred an appeal, which is their statutory right. Appeal has been admitted. Only stipulation is that they are not even asked to pay. In many cases, we have seen when revisions have come, the Honorable Court has directed that let the maintenance be kept paying. Keep paying the maintenance. That they are not burdened with that. They have only been asked to pay 50% of the maintenance amount. Let the appeal be heard on all of these facts, my lord. The appeal court will decide, appellate court will decide whether they have a case, whether we have a case. While the appeal is pending, approaching this honorable court, and that too challenging an interlocutory order which is barred under 397(2), my lord. This is, my lord, an futile exercise, my lord, and abuse of the process of law, my lord. Let them agitate their case and appeal, my lord, whatever be the outcome, my lord. Then they can make come if they have any grievance, my lord.
Lordship. Lordship, we need to go through the Supreme Court judgment. And moreover, Lordship, some of the points which I have remembered while my learned friend said. So, your Lordship, we doesn't know whether respondent number 2 is claiming maintenance from her earlier husband. We are unaware of the fact yet, whether she is claiming or not. And moreover, Lordship. Yes. Lordship, Lordship, since Lordship, this case is registered under DV Act, they should also establish the case that domestic violence had really occurred. So for this case, LCR may be called for, Lordship, because in the earlier occasion, LCR has not been called for. LCR may be required to. No, Lordship, I have just gone through it now.
No, my lord, one more thing, my lord. Again, calling for the LCR would mean that your Lordship would examine the merits of the case. Here they are agreed with that 50% order, my lord. That, apart from all other issues, my lord, that order is maintainable.
Lordship, my grievance is also, no, Lordship, my grievance is also that in this matter, not only that 50%, but the entire thing that. Yes, your Lordship. Yes, your Lordship, because I have to look after, Lordship, I have to look after my 4 children. I have my ailing old parents. Yes, your Lordship. Yes, your Lordship. Lordship. Yes, your 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 Lordship, another date may be fixed.
My lord, now I am.
Lordship, a direction may be given, Lordship, a direction may be given that we may not be imposed with conditions. Like the learned session just has to the pending, the appeal which is pending, your Lordship.
No, but they are saying that if your Lordship is disposing of the matter, then
Yes, your Lordship.
direction may be given that that condition may
That
not be.
condition may not be complied with.
That 50%.
Yes, your Lordship. Yes, your Lordship. Yes, your Lordship. 50% not, yes, your Lordship. Yes. Lordship may dismiss this, dispose of this post.
That, in my lord, that 397(2) bar may also be considered.
The money and supply.
Lordship, then another date may be fixed. Lordship, I need to go through it. Another date may be fixed. Yes, your Lordship. Yes, your Lordship.
Because my lord, now I am not getting maintenance. Because they have a stay in the appeal as well as in the DV proceeding. No execution, nothing. I am not receiving 2023 matter, my lord. I am not receiving any maintenance. stays there, both in the appeal as well as in the original DV execution proceeding. May I pray, my lord, matter, because this is an issue of, no, because we are appealing for the first time today, my lord. Yes, my lord. No, my lord. My lord, DV case was filed. We were there, the award was given. We are appealing for the first time, my lord. We only we are appealing for the first time today. So they got a stay. We got to know from the court that a stay has been given. So knowing that, my lord, we filed a wakalatnama and we are appealing. May I pray, my lord, whatever be the issue, my lordship may finally dispose of the matter, my lord. Otherwise causing tremendous prejudice to me, my lord.
Lordship, Lordship, one more direction may be given, a written objection may be filed by them. By them. No, Lordship, it may be in the record of the case. It may be in the record of the court.
Up to us, we may file, may not file.
Yes, your Lordship, yes. Yes, your Lordship.
My lord, that is the only problem, my lord. Otherwise, I am not from 23, my lord, I am not getting maintenance. And original case is from 2018, my lord. 18 case. Part otherwise, my lord, I do not know when it will come up.
29.
My lord, my lord, I have a case, my lord, item number 42.
My lord, will keep it as part then. Part 29. Deeply obliged.
My lord, item number 42. My lord, my client is in jail, my lord, for about 1 year, 4 months. Every time, my lord, bail petition is coming before your lordship, but it is not reached. So, my lord, may I pray that it may be listed again, my lord, with some date, my lord. With some date. My lord, date may be given, my lord, in before Bihu, my lord.
Well, item number 34, my lord. Well, item number 34, several of
In
these
that
listed, my lord.
case, my lord, after Bihu, a date may be given.
May it please, your
On the-
lordship. Item 48, my lords, last item of the list. My lord, there is a modification in the order required, my lord. Some urgencies there. May lordship may kindly take it on Friday. My lord, on 3rd, if I may pray. Next week. My lord, modification would not take much time of my lords. My lord, on 3rd, my lords.
Well, item 34, my lord.
Item 48, my lords.
Similar prayer in 33, item number.
Notification very important, you say?
Modification of the
Oh.
order. So, my lord.
Due to
My lord.
They're not on it.
Oh, dispose of it.
No, I'm not saying before, my lord. Let it be after view, my lord. But fix a date, my lord, at least.
Well, my lord, in my case, my lord, 3rd, I'll try my luck, my lords, on 3rd.
Well, kindly, my lord.
Fourth, my lord.
Item 40 and 41, my lord.
Item 30, 39.
My lord, Court master will give the date, my lord. Maybe allow.
Lordship, item 36,
Yeah.
Lordship, CD was called.
Still
what year
give
it
the
was
date,
back,
my
Lordship?
lord.